Thank you so much. Good morning, everyone. I'm going to call the Assembly Committee on Judiciary to order. Madam Secretary, would you please call the roll?
Assemblywoman Bilbray Axelrod.
Here.
Assemblywoman Cohen.
Here.
Assemblywoman Gonzalez.
Here.
Assemblywoman Hanson. Assemblywoman Hardy.
Here. Here.
Assemblywoman Kasama.
I'm here.
Assemblywoman Krasner.
Here.
Assemblywoman Marzola.
Here.
Assemblyman Miller.
Present.
Assemblywoman Wynn.
Here.
Assemblyman O'Neill. Assemblyman Orntlicker.
Here.
Assemblywoman Summers Armstrong.
Here.
Assemblyman Wheeler.
Here.
Chairman Yeager.
Here. Please mark Assemblyman O'Neill absent excused until he returns. I expect him to be back with us shortly. Everyone else is present. That means we do have a quorum. Good morning to members. Good morning to those in the public who might be watching us either on the legislature's website or the YouTube channel. And welcome to day 40 of the 81st session of the Nevada Legislature. That means we are now 1/3 of the way through session. So pat yourself on the back for that. There's a lot of work in front of us, but there's also a lot behind us. So before we get started with this morning's agenda, just a few housekeeping matters. For anyone on the Zoom, please make sure you're on mute unless you're speaking. That'll help with the audio feedback that we sometimes get. And for presenters who are on the Zoom with us, please remember to state your name each time before you speak, particularly when you're asked a question. That'll also help with the minutes. And if you forget to do that, I'll try to remind you because it's not normal. We do expect courtesy and respect in our interactions with one another. We don't always agree on policy. Perfectly okay, but we need to make sure we're being respectful of one another, the legislative institution, as well as our hardworking staff. Finally, many of the members will be using multiple devices to access this meeting: laptops, desktops, extra monitors, iPads, iPhones, and the like. So please don't see it as a sign of disrespect if members appear to be looking away during the meeting. Most likely they're trying to access exhibits or take notes on what's going on in the meeting. It's simply the virtual world that we live in. With those housekeeping matters behind us, we'll move on to our agenda. Members of the committee, members of the public, just to give you a little bit of the lay of the land, we are going to take the bills in order as they appear on the agenda. You'll also note that we have a work session. We're going to take that work session either after the first or second bill, depending on timing. And so if our folks who are on the Zoom for the work session, I just ask you for your patience. We'll try to get to the work session as quickly as we can. I just want to make sure we have all members present and able to vote on the work session document. So at this time, I'm going to open the hearing on Assembly Bill 212. Assembly Bill 212 makes various changes relating to court interpreters. And before I hand the presentation over, I'll let committee members and members of the public know there is an amendment that you can find up on Nellis for this bill. So my guess is that our sponsor will cover that at some point during the presentation. But I want to welcome to the Assembly Judiciary Committee for the first time this session, our colleague, Assemblywoman Natha Anderson. And she's going to present the bill. I think she has a couple of folks with her to help her do that. So Assemblywoman Anderson will give you a chance to present, and then I'm sure we'll have some questions. So welcome to the Assembly Judiciary Committee, and the floor is yours.
Thank you, Mr. Chair. Good morning, Chair Yeager, Vice Chair Nguyen, and members of the Judiciary Committee. It's really wonderful to be presenting my first bill, actually, to such a wonderful committee. My name, as already mentioned, is Natha Anderson, and it is my honor to represent Assembly District 30. Today I'm bringing forward for consideration AB 212. The court interpreters who I've been working with for the last few weeks on this are bringing this language forward because they truly believe that the phrase justice for all is not just an empty phrase. It is more than a pledge. It is a belief. Too many of our individuals, when they are appearing in the courts, do not always have the same language access. And so this is a way to start to address some of those issues. In 2016, the U.S. Department of Justice Civil Rights had a report that actually has many different elements in it, and it was about all of the different court systems, across the nation. It dealt mostly with registered court interpreters and how exactly are we providing this idea of justice to individuals who do not speak English as their main language. Unfortunately, in this report, Nevada had a score of 16.8 on key measures. And if we were on a 20-point scale, that'd be wonderful. But we were on a scale of 100. And so we've got to start to make some changes. And some of those changes have already been started, actually. One element that is part of this is a report that is done on a every other year basis that all courts are expected to do, which is called the, let me make sure I've got the right words. It is the language access plan. And every other year, the courts are expected to turn in something to the administrative office of our Supreme Court to look over it. And then there's a committee that actually studies this language. Last year, the committee was unable to meet. Because of COVID, as well as the fact that the individuals serving on it are volunteers and are incredibly overworked. At the same time, we have to do something to make sure that justice for all is truly something that is happening. Instead of me continuing, actually, I would like to turn it over to two individuals who have been very intimate with this. One is Jimena Chica, and I want to make sure I'm saying the name correctly. She is the president, actually, of the association that's bringing this forward. And then also Manuel Medreos of Northern Nevada International Center. So before I go into the bill, with the chair's permission, I would like to ask those two individuals just to quickly go into their experiences, if they could, please.
Thank you so much, Assemblywoman Anderson. That would be fine. Do we want to start? Why don't we start with, is it Miss Chica?
Miss Chica.
Yes.
Why don't we start with Miss Chica?
Okay.
Please go ahead.
Good morning to the Assembly, the Chairman, and the President of the Assembly, and especially to Assemblywoman Anderson. And special thank you to her for bringing this bill forward to the Assembly on our behalf. As said before, my name is Jimena Chica. I am currently the President of the Nevada Interpreters and Translators Association. And I am also a certified court interpreter and have interpreted in court for 2 years now. I would like to give you a little bit of information about the sort of the real life and day-to-day of the situation of court interpreters and their relationship to this bill, and the relationship to the Nevada Administrative Office of the Courts. So, as I said, I'm a court interpreter. That means that in courts, I stand next to a person of limited English proficiency. We call them LEPs. So I'll stand next to an LEP and make sure that that person, I whisper into the ear of that person everything that is going on around them in the courtroom. And then I also ensure that that person has a voice within the courtroom before a judge, sometimes a jury, not often, of course, a jury, but sometimes the jury and the other party, etc., and that person's voice is heard. In other words, what I do is I guarantee to people of limited English proficiency their 14th Amendment right to due process and to participate in the due process that's going on around them, which would obviously mean that they have to comprehend what's going on around them in a courtroom. This person of limited English proficiency is on occasion a mother that is fighting to be understood so that she can keep custody of her children, or a father who would like to have or keep custody of his children. It can be a family who is trying to stay in their home. It could be, on many occasions, it's the property owner who is also, wrestling to keep rights over their property. business owners on many occasions, but it is also, for example, people who are being brought to justice for a crime committed. So I will stand on occasion next to a murderer or a drug trafficker or a rapist, and I will make sure that that person understands the crime that is the accusation that's being brought against them, the process that goes on to determine their punishment for that crime, and the reasons why they are being and how they are being punished for the crime committed. So I consider that our position within the court is very important, and it's not to be taken lightly. None of us take this responsibility lightly. We are highly trained individuals. It is necessary that we be trained, tested, and tried, that we go through many hours of observation. And there's a system that is established so that we can do this. To give a little bit of contextual history of that system, in the year 2002, the Nevada Administrative Office of the Court created the Certified Court Interpreters Program, right, where we receive a little bit of training, but mostly we are tested and certified to participate in the system, or in languages that have no testing, we are registered to participate in the system. This is for languages that are less common, for example, Japanese or languages spoken in the Pacific Islands, or a lot of the African languages like Eritrean, which is Ethiopian, and so on. So there are many of us, and there are many languages, and so because there's an immense variety of languages that are spoken in the state of Nevada, and a lot of the people who are limited to this language or that don't altogether understand English or have, as we say, limited English proficiency, go before the courts and need someone like us. So as I was saying, in 2002, the program, the Certified Court Interpreters Program, was created. In 2013 was the first attempt of the Language Access Committee within the AOC to create what is called the Language Access Plan, which Assemblywoman Anderson just referred to. In 2016 was the report, so 3 years after the creation of the Language Access Plan, was the DOJ's report, in which the state of Nevada did very, very poorly with reference to the actual reality of language access within its courts. And then in 2019, due to this poor grading in the DOJ report, in 2019, there was a revamping within the Nevada AOC of the Language Access Plan. It was improved, and so on. It was tried to make it more executable, trying to give people of limited English proficiency more access to us and give us more access to them. The reason why we wanted to put forward this bill at this moment, however, despite the already existence of a language access committee within the AOC, a language access plan that has been worked on and revamped, is that we have no access as interpreters. We have no access to this committee, right? So all of the decisions that are made regarding us and regarding language access within the courts disregard the presence of an interpreter there, who is the person who has direct access to language access within the courts. So one of the elements that we are requesting in this bill is that there be interpreters representing interpreters, court interpreters within the committee that makes decisions on the reality of language access within the courts.
Thank you so much, Ms. Chica. I'll be going over the bill elements in just a moment. So
thank you very much.
So much. So
having said this, thank you very much for the opportunity to address the committee, give you a little bit of context about who we are and why we're here. Thank you very much.
Thank you, Assemblywoman Anderson. I would note that you may be channeling your father there and keeping us moving along, as he did so aptly over years chairing this Judiciary Committee. So Ms. Chica, thank you for your comments. And we're going to go next to Mr. Medeiros, who's on the Zoom with us as well. Sir, if you could please state your name and provide your testimony, would appreciate it.
Sure. Good morning, Chair and members of the Assembly Committee on Judiciary. For the record, my name is Manuel Medeiros, and I'm the Language Access Specialist for the Northern Nevada International Center. Before I provide my brief comment, I wanted to thank publicly the champion behind the bill, which you heard her name, Assemblywoman Natha Anderson. Thank you, Assemblywoman, for the commitment to education, community, and language access. Ladies and gentlemen, I sit virtually in front of you to support Bill 212, AB 212. This bill is very straightforward, and in my own personal opinion, it adds even more diversity to the commitment that advises the court administrator. In particular, for adding a committee member that represents a language other than Spanish, which is critical since we are now living in a global economy in our state. In addition, AB 212 allows the committee to celebrate their annual accomplishments and feature them in a public report, which in turn spotlights their hard work, spotlights their critical work, spotlights their important contributions, and lastly, the report spotlights their commitment to the profession of interpretation, language access, and our limited English proficiency individuals in our state. Very briefly, I wanted to let you know that the state of Nevada is very fortunate to have court interpreters, which are trained professionals that go through a vigorous process to become fully certified. They're required to do so and provide many continuing education credits to their professional language and interpreting skills at their very best level. They wanted to do that so that they can keep that at their very best level. All these professionals love the art of interpreting. Better yet, they care, protect, and love their profession so much. You see, I speak Spanish very fluently. However, if you put me in a court setting, I'm not a non-trained interpreter. I will fall apart and do not know what I'm supposed to be doing or saying. And yes, I would make many mistakes. Just because I speak the language, that does not make me a trained interpreter nor a competent one. No limited English proficiency person deserves an individual like me in a court setting. They deserve a certified court interpreter, someone who lives and breathes legal terminology every single day, because they live and their freedom might depend on that. A court interpreter needs to possess not only a deep understanding of the language in which they specialize, but also a high level of knowledge about the justice system and criminal procedures and legal ethics. In closing, I wanted to thank all of you and all the body for hearing AB 212. I hope that all of you support AB 212. Thank you so much for this opportunity to speak in front of you and for allowing me to spotlight the profession of interpretation and the importance of our limited English proficiency persons in our state. I appreciate all of your time. Have a great morning.
Thank you, Mr. Medeiros. We appreciate your testimony. Assemblywoman Anderson, we'll hand it back over to you to take us through the bill, please.
Well, I think both of them started to do so that was great. I should have practiced a little bit more, it's true. So I'm just going to walk through the amended language that I believe all of you should have received both yesterday and then is also on Nellis, as Chair Yeager had mentioned. This is just one more step in how we continue, though, to improve the ability to provide the language access for other individuals. Number one, it expands the number of individuals on the advisory committee. Expands it by two. There's one individual that will be a specialist in the Spanish language, and the second will be an individual who is not in the Spanish language. I was asked yesterday if this would include as well, I believe it was Assemblymember Brown May who asked me if this could possibly include an individual who was an interpreter for the deaf, and I said, of course. That would be fine as well, because all languages should be represented, and that is considered to be another language as well. So that is the first thing that it does under 1.4. Under that addition on the original language that I had submitted. The second thing it does is it clarifies that the report should be submitted to the Nevada State Legislature in addition to the Chief Justice. And then also that report should be made readily available. It is an important thing for us to also get it here in the legislature. So this way we can start making some data decisions. Too often we get told anecdotal things. This would allow us to see the reports that are coming and to try to make those connections. And I know all of you open up those envelopes every month and read every single report you receive, but this will be an email, so that way it'll be easier for you to receive those. Possibly. I think the other thing that is a big thing is what exactly will be in that report. It is going to be utilizing the language access plan. As was mentioned by Ms. Chica, the latest one that is on the website is from 2013. Yet we know that, or based upon information from a recently termed out member of this committee, there is a more updated plan, but we don't know what that plan is. And so we'd like to have that also readily available. I do have a copy of the Reno Justice Court's report. If this committee would like me to submit it to you, more than happy to do that. So this way you can see what exactly is on that report. There are numerous elements. It includes, it could include the number of individuals that have been asked to actually be interpreters, what services were provided, number of languages that are being utilized, so we can start to zero in on, are we really giving the best, or do we have enough people in this field right now? Finally, it does ask for a reporting of the number of employees who oversee or coordinate the court interpreters. I believe recently the AOC office had some changes going on, and so the person that was overseeing this, I believe it recently retired maybe a year ago, and some of the changes have happened, or some of the path that we were going down kind of got diverted because of that. Good news is there is a new director for the AOC. I believe it is a Miss Stocks, and I want to put it on record as well. I have not contacted Miss Stocks about this bill. It was in my plans to do so, and then when the bill dropped on Monday, and thank you, Chair Yeager, for hearing this so quickly. It was in my plans, and yeah, sorry, I'm a bad person. But I will be contacting her about it. That's basically what this plan does, is first clarify the report, expand the number of people, and then also allow for a little bit more opportunities for us to make changes. But thank you again for allowing me this time to present, and I'm more than happy to take on any questions to the best of my ability. Thank you, Mr. Chair.
Thank you so much, Assemblywoman Anderson, and your two guests that were here. And, I just want to take a moment. Many of you know that for a long time I practiced in the criminal courts down in Clark County, and I just want to thank our interpreters. I mean, they are amazing in what they do. And I remember having a jury trial where my client was Spanish speaking, and there were several witnesses that were Spanish speaking. So we had multiple interpreters in the courtroom, all doing their thing, trying to interpret contemporaneously, which I thought was just very, very impressive. So I want to thank all of you for your hard work and the fact that you care so much about making sure individuals have access to justice and understand what is going on in the courtroom. Do we have questions from committee members on this bill in front of us? If you could raise your hand in front of your screen. So far I see we have Assemblywoman Hardy, and let me just see if there's anybody else raising their hand at the moment. We have a lot of folks with us today on the Zoom, so I have to scroll through a couple of screens. So we'll start with Assemblywoman Hardy, and then we'll take it from there.
Thank you, Chair, and thank you for bringing this bill. During my years of working in the courts, I interacted a lot and saw the great work that court interpreters do in providing access to justice. So I think this is a good idea. I just had a couple of questions. How many languages do you know, or do we have in the courts that we can interpreters currently, like different languages? That's the first question. And then where it says you would have an interpreter in a language other than Spanish, how would you determine what other language would be chosen?
Thank you for the question. So I am going to hand this over to Ms. Chica, but before doing so, I had the same question of the first one of how many languages are there? Well, I sat down and started trying to figure that out. Impossible. There are numerous. I mean, like I was talking with somebody about it. You might have Tongan. There's just the group that I was meeting with the other night. There was a Japanese, I believe Ms. Chica is actually Spanish and trying to get the Portuguese. There are Spanish, but then also sign language. So there's so many that I think it's almost impossible just to define that. However, I will hand it over to Ms. Chica to try to answer that. And then the other question for the determination, I think at this time, the committee is decided upon by the Supreme Court Justice. He is the individual who makes that decision, or she. is the individual who makes that decision. And so it would be whoever is certified in any other language other than Spanish to be able to choose from. I believe is what the language says, but I will double check that as Ms. Chica is answering the question if possible.
Okay, thank you, Assemblywomen, both for the question and for the possibility of answering it. There are 5 or 6 languages that are currently there are currently certification exams for, right? So these languages are the more commonly spoken languages: Spanish, Portuguese, French, Mandarin Chinese, and Cantonese, and I'm a little hard pressed to name them all right now. Russian, and then there are the languages which I think simply Nevada, the AOC has not had enough frequency to create an exam for, nor do they have a certified interpreter that they could, or an interpreter, a highly experienced interpreter that they could create the test with. So so these languages are, as I said, the less commonly spoken languages are less frequently used languages in court, such as Japanese, Northern African languages. I believe Arabic is in that group, although Arabic is quite highly frequently spoken. So the saying which languages are the registered languages or the languages other that are not the 5 or 6 that we have certifications for. There are many, and as need arises, then somebody will come out of the community and say, okay, well, I could register and I could train and I could become sort of the interpreter for my group before the courts. And hard to number, in other words, it's hard to number.
Thank you. And then also, just to clarify the second part of the question, the list of recommendations, it's listed on section 1.530.1. It's basically a list submitted by the court administrator to the Supreme Court, to the Chief Justice. They're the ones to make that decision. And so it would be other individuals who might be interested as to how that they would like to be appointed to that.
Okay, thank you.
Thank you.
Do we have
and I
other?
forgot to say
go ahead.
that was Natha Anderson with the last little bit. Before that, it was Ms. Chica. Sorry.
Thank you, Assemblywoman. Do we have other questions on Assembly Bill 212 as presented with the amendment? Let me scroll through here to make sure nobody has their hand up. Okay, I don't see any additional hands up. So Assemblywoman Anderson, Ms. Chica, Mr. Medeiros, I want to thank you for presenting. I would ask you just to sit tight for a moment as we take testimony on the bill, and then we'll come back for any concluding remarks you may have. So at this time, I'm going to open up the testimony in support of Assembly Bill 212. I don't think we have anyone on the Zoom who hasn't already testified in support, but if I'm wrong about that, please feel free to turn your camera on, unmute, and just let me know that you'd like to testify in support. And we'll give everyone a second to do that. Okay, I don't see anybody on the Zoom. BPS, could we go to the phone lines to see if there's anybody there who'd like to give supportive testimony for Assembly Bill 212?
Good morning. Thank you, Chair. For callers wishing to testify in support of Assembly Bill 212, please press *9 now to take your place in the queue. And we will begin with caller with the last 3 digits of 130. Caller, please slowly state and spell your name for the record. You have 2 minutes to speak and may begin.
Good morning, Chair and members of the committee. For the record, my name is Christine Saunders. That's CHRISTINE SAUNDERS, and I'm the Policy Director with the Progressive Leadership Alliance in Nevada. First, we want to thank the Assemblywoman for bringing this important bill forward. We all know that the legal language is difficult to understand for most folks who don't have a law degree. Court interpreters are essential for criminal justice to ensure accurate communication, give every individual a voice in the process, and are helpful to avoid delays and drop charges. AB 212 is an important step to help Nevada increase access to court interpreters, and as they are the most knowledgeable, should be involved in the process to improve the program. We urge your support. Thank you.
Thank you for your testimony and support, Ms. Saunders. BPS, are there other callers in support?
Yes, we will go with the next caller with the last three digits of 660. Caller, please slowly state and spell your name for the record. You have 2 minutes to speak and may begin.
Mr. Chair, members of the committee, my name is Olivia Whiteley. That's Olivia Whiteley for the record. I'm an advocacy officer for the Refugee Advocacy Lab, and I ask you to support AB 212. Over the past several months, I've surveyed Nevada's resettlement agencies, and the number one shared concern of these agencies is language access, particularly for refugees that speak uncommon languages, such as Kituba and Lingala, spoken in the Democratic Republic of the Congo, or Tigrinya, spoken in Eritrea. AB 212 supports refugees both in their search for equity in everyday legal activities, such as COVID-related eviction hearings or general family proceedings, and economic opportunities through employment. As individuals in need of language services, AB 212 supports refugees by requiring an annual report that contains information on the activities of the AOC's committee. This provides an additional measure of transparency on the policies and procedures used to provide language access. Members of the refugee community would then be able to recommend revisions to those processes, such as further activities regarding infrequently spoken refugee languages, literacy considerations, or cultural competency training. Further inclusion of statistical information regarding the need for language services ensures that refugee languages, which are often less frequently spoken, are accounted for in judicial proceedings. As individuals who become translators and interpreters, AB 212 invests in refugees by increasing the representation of interpreters on the AOC's committee. The inclusion of an interpreter that works in a language less commonly used ensures procedure support rather than hinder refugees that work as interpreters, as the optimal number of required working hours, trainings available, and cultural considerations may differ significantly from the Spanish language standard. Thus, I urge you to support AB 212. Thank you for your time.
Thank you for your testimony, Ms. Whiteley. BPS, is there anybody else who'd like to testify in support?
Yes, thank you, Chair. May we go with caller with the last three digits of 261. Caller, please slowly state and spell your name for the record. You have 2 minutes to speak and may begin.
Good afternoon, and thank you, Chair, members of the committee. My name is Jillian Block, Gillian Block, speaking in support of AB 212 on behalf of the Coalition of Legal Service Providers. Nevada is a multilingual state, and access to language interpretation services is critical for access to justice. Improving language access can make a world of difference to our clients who already face significant barriers when accessing the courts. Every person deserves a meaningful opportunity to understand their rights, responsibilities, and obligations when they come into contact with the justice system. And this legislation will help ensure that all Nevadans, regardless of language or national origin, are able to access court services and information. Thank you.
Thank you for your testimony, Ms. Block. BPS, are there other callers in support?
Thank you. For callers wishing to testify in support of Assembly Bill 212, please press star 9 now to take your place in the queue. And Chair, there are no further callers in support at this time.
Thank you, BPS. I will close supportive testimony. I will now open opposition testimony. I don't believe we have anyone in opposition on the Zoom, but if I'm incorrect about that, please turn your camera on, unmute, and let me know you'd like to testify in opposition. Okay, I don't see anyone on the Zoom. BPS, could we go to the phone lines to see if there's somebody there who'd like to offer testimony in opposition?
Yes. For callers wishing to testify in opposition of Assembly Bill 212, please press star 9 now to take your place in the queue. For callers wishing to testify in opposition of Assembly Bill 212, please press star 9 now to take your place in the queue. Chair, we do not have any callers raising their hand in opposition.
Thank you, BPS. I will close opposition testimony. I will now open neutral testimony. Is there anyone on the Zoom who would like to offer testimony in the neutral position? If so, please turn your camera on, unmute, and let me know. It's 2 screens of Hollywood Squares today, so it takes a little bit of time to scroll through. Okay, I don't see anyone on the Zoom. BPS, I believe we might have 1 caller, or perhaps more, in the neutral position on the phone line. So can we go to the phones and queue up the first caller, please?
Thank you, Chair. For callers wishing to testify in neutral of Assembly Bill 212, please press star 9 now to take your place in the queue. And we will begin with caller with the last 3 digits of 663. Caller, please press star 6. And please slowly state and spell your name for the record. You have 2 minutes to speak and may begin.
Good morning, Mr. Chair, members of the committee. This is John McCormick. I'm the Assistant Court Administrator at the Administrative Office of the Courts. The name is John, last name Mccormick. I'm calling in neutral on the content of the bill this morning, and want to put on record that the Administrative Office of the Courts is happy to work with the sponsors of the committee in any way we need to on this bill. I would like to point out briefly that statutorily the court interpreter program at the AOC does not include interpreters for in American Sign Language or for people with hearing impairment. That is actually regulated through the Department of Health and Human Services. Additionally, I can provide some clarification as far as the program operation at AOC. We did have our coordinator leave us last February and have been unable to fill that position since due to the pandemic related budget cuts that have been necessary. So myself and other staff have been filling in, and it has been difficult during the pandemic to provide adequate testing because testing does have to happen in person. However, not to sort of belabor any of these points, but again, I would just like to say on behalf of myself and Ms. Stocks, our new court administrator, that we're happy to work with the committee and the sponsors in any way necessary.
Thank you so much for your testimony, Mr. McCormick. BPS, is there anybody else in the neutral position?
We are currently in neutral testimony for Assembly Bill 212. If you have recently joined the call and would like to testify in neutral, please press star 9 now to take your place in the queue. Chair, the public line is open and working. However, there are no callers for neutral at this time.
Thank you, BPS. I will close neutral testimony. Assemblywoman Anderson, I would hand it back to you for concluding remarks, and I'll leave it up to you whether you'll be the sole person with concluding remarks or whether you'd like your other presenters to make remarks as well. So please go ahead.
Thank you. And although I'm sure that both would like to, I think I'm just going to make it very quick because I know that you all have a very packed agenda. I will be reaching out to Mr. McCormick as well as Ms. Stocks to try to figure out what's all going on. So I thank him very much for that clarification around the sign language. I was unaware of that, so I'll make sure that Ms. Brown-May knows about that as well. In closing, thank you for this opportunity. And I would just like to point out that the state of Nevada has a very rich history in honoring our translators. Sarah Winnemucca is probably the most famous of our translators. And I just wanted to bring her name into the room as well to show how we have always honored them. And I believe this is another way for us to do so. Thank you for this opportunity again, Chair Yeager.
Thank you so much, Assemblywoman Anderson, and thank you to your 2 co-presenters. You did a wonderful job presenting your first bill in front of the Assembly Judiciary Committee. It was an honor to have you here this morning. And again, thank you guys for joining us for a little bit of time here on Friday morning. I hope you have a fantastic rest of the day.
Thank you.
Okay, I will now close the hearing on Assembly Bill 212. And members, just sit tight for just a second while I figure out what we're going to go to next. Okay, thank you everyone for your patience. It doesn't look like we have all of our members back yet, so we're going to hold off on the work session for just a little while longer. And committee members and members who are on the Zoom, guests who are on the Zoom for the work session, just ask for your patience. I don't think the next bill is going to take too terribly long, so we'll get through that and then go to the work session. So at this time, I'm going to open up the hearing on Assembly Bill 214. Assembly Bill 214 revises provisions governing sexual assault. For members of the committee and members of the public, I will let you know there is a proposed amendment that you can find on Nellis. And I want to welcome to the committee for the first time this session, Assemblywoman Hanson. Welcome to the Assembly Judiciary Committee, and we'll give you and any of your guests a chance to make the presentation on the bill, and then I'm sure we'll have some questions. So welcome again, and please proceed when you're ready.
Thank you very much. Thank you, Chairman Yeager, Vice Chair Wynn, and committee members. I am so happy to be in Judiciary this morning and be able to present this bill. My name is Assemblywoman Venetia Considine, and I am here to present AB 214. Simply, this bill removes gendered language in NRS 200.336, which is under the sexual assault and seduction section of Chapter 200. There are 5 changes that have been made throughout this section, easy to find within the bill, but I do want to point out what Chair Yeager said earlier. There is a conceptual amendment. Before I go through the bill, I do want to let you know that Serena Evans from the National Nevada Coalition to End Domestic and Sexual Violence is here to present this bill with me as well. So my goal is to go through the bill, explain the conceptual amendment, and then turn it over to Ms. Evans to do a little bit of testimony and then take some questions. So AB 214 in subsection 1, 1A, 1B, and 5B removes language him or her or himself or herself and replaces that language with ungendered language. The reason for this is twofold. One is to recognize that there is a spectrum of genders, so that the assault statute can be eligible for anyone, or anyone can utilize it. Also to ensure that the understanding that men can also be victims of sexual assault. Also, we did this to align it to other NRS chapters throughout NRS, to align it with the goal of degendering that language. So, for example, domestic relations, I believe, was changed in the last 2 sessions to fix that language, and this just aligns with that idea. So the conceptual amendment is specifically for subsection 1A. The second section in there subjects another person to sexual penetration or forces another person to make a sexual penetration. The original change was that person. What this conceptual amendment does is it takes out that person and changes that to themselves. So it would then read, subject another person to sexual penetration or forces another person to make a sexual penetration on themselves or another, or on a beast against the will of the victim, or under conditions in which the perpetrator knows or should know the victim is mentally or physically incapable of resisting or understanding the nature of the perpetrator's conduct. So it's a simple bill. It's just a few changes to it, but I think it does make a big difference. And if there's no questions for me at the moment, I would like to turn it over to Serena to talk about it as well.
Thank you so much, Assemblywoman. Appreciate those remarks. We'll turn it over to Ms. Evans, and then we'll open it up for questions. Welcome, Ms. Evans, and please proceed.
Good morning, Chairman Yeager, members of the committee. Happy Friday. My name is Serena Evans, and I am the policy specialist for the Nevada Coalition to End Domestic and Sexual Violence. For those of you who are not familiar with NCEDSV, we are the statewide coalition of domestic and sexual violence programs throughout all of Nevada. So I want to first thank the Assemblywoman for working with us along with many other stakeholders throughout the interim to work on this issue. So since last session, I'm so sorry, excuse me, fighting a head cold. I was contacted from a few programs and sexual assault advocates throughout the state expressing interest in wanting to work on the Nevada revised statute definition of sexual assault. So in response to the reoccurring interest in this topic, we at the coalition convened a work group of sexual assault advocates throughout the state, and we held this work group in July of 2020. And pretty much this work group was loosely constructed work group where I was really just listening to the concerns that advocates were raising. And we had a conversation around what the ideal definition of sexual assault would look like for Nevada. And one of the concerns, among others, that arose out of this work group was that the current gendered language used in the NRS 200.366 was problematic and not necessarily inclusive of all victim survivors. So many clients that our wonderful advocacy organizations serve don't necessarily identify as female or male and fall onto the gender, the non-binary gender spectrum. And so the current himself and herself language that is used is exclusive of these non-gender conforming survivors, and many LGBTQIA+ survivors didn't feel safe to come forward about their sexual violence victimization, and they also felt that their victimization was not truly valid or taken seriously with what the current gendered language being used. Like the Assemblywoman mentioned, the other part of this conversation was that there's this traditional narrative within sexual violence that it's usually a male perpetrating a female victim, and we know that that's just not true. Anyone can be a victim survivor regardless of their gender, and anyone can unfortunately be a perpetrator as well regardless of their gender. And so replacing this language with themselves or the perpetrator and the victim really gets rid of that traditional narrative. It allows people, victim survivors, regardless of the gender of themselves, regardless of the gender of their perpetrator, to feel comfortable and safe coming forward and sharing their story. Like the Assemblywoman mentioned, this is a very small change in the statute, but we know that inclusive language is necessary for the safety of everyone. Language is powerful. This small change will really, truly have a meaningful impact for victim survivors throughout the state. I want to also note that according to the U.S. Department of Justice, sexual assault is the most underreported violent crime, with only about 1/3 of victim survivors reporting to law enforcement. So if we can make this small but meaningful change to increase the likelihood that more survivors will feel comfortable enough to come forward and potentially report to law enforcement, that means we are increasing the likelihood that more perpetrators are being held accountable. So again, I really want to thank the Assemblywoman for her willingness to take on this piece of legislation to address the needed change in our sexual assault definition. Like I mentioned earlier, this piece of legislation is honestly the first step in what is a larger effort to make positive changes in the sexual assault laws in Nevada. And so at the coalition, we plan to work on this issue through the interim and beyond, however long it takes, to collaborate with all stakeholders to address not only the definition, but the prosecution and adjudication of sexual assault in Nevada. So with that, I'm happy to answer any questions that you all may have.
Thank you so much, Ms. Evans and Assemblywoman Considine, for presenting Assembly Bill 214. Committee members, do we have questions about the bill for our bill sponsor? If so, if you could please raise your hand in front of your monitor, or otherwise let me know in some way that you have a question. You might get off easy, Assemblywoman. We might not have any questions. It's one of the benefits of going on Friday. We're worn down from the week. I guess I have a question and maybe just a quick comment. And Assemblywoman, I wanted to just ask, I think this particular concept in the bill was one of the concepts that was worked on by our former colleague in the legislature, Assemblywoman Monk. And so I just wanted to confirm that, and if so, obviously thank her for her work on this, and thank you for picking up where she left off and running with this bill. So if you have any comments on that, I would appreciate it.
Thank you, Venetia Consoline, for the record, and thank you for bringing up previous Assemblywoman Monk. This originally was her bill from the last session. The conception of this bill was much larger than this, but as Ms. Evans said before, there is a long-term plan to work out other issues under this NRS, but we didn't want to lose the opportunity to do something small yet very meaningful that we could get done now as a beginning part. But the genesis of all of this, that credit does have to go to former Assemblywoman Connie Monk.
Thank you for that. And Assemblywoman Monk, I don't know if you're watching, but if you are, I just want to say thank you for your work on this issue. And I'm glad Assemblywoman Considine was able to pick it up and run with it. And I think there's probably more work to be done, but we'll take it one step at a time. Committee members, any questions before we move on to testimony? This is the last call for questions. Okay, I don't see any questions. So Assemblywoman and Ms. Evans, I just ask you to sit tight for a moment. We're going to see if we have any testimony on the bill, and then we'll come back to you for concluding remarks. Is there anybody on the Zoom with us this morning who would like to testify in support of Assembly Bill 214? If so, please turn your camera on, unmute, and let me know. I think most of our folks on the Zoom are here for the work session, so I don't see anyone for this bill. BPS, could we go to the phone lines to see if there's anybody there who'd like to testify in support of Assembly Bill 214?
Thank you, Chair. For callers wishing to testify in support of Assembly Bill 214, please press *9 now to take your place in the queue. We will begin with caller with the last 3 digits of 402. Caller, please slowly state and spell your name for the record. You have 2 minutes to speak and may begin.
Good morning, and thank you, Assembly Committee. My name is Dr. Margaret Campy. You spell my name Margaretcampe. And thanks for having me, and thank you especially to Assemblywoman Considine and Serena for your hard work on this bill. I am the director of the UNLV G-Nidich Care Center, where CARE stands for Campus Anti-Violence Advocacy Resources and Empowerment. And I'm here to testify in support of AB 214. So gender-neutral language in legislation is imperative, especially as it relates to interpersonal violence, including sexual assault. Although much of the earlier research, as noted by Serena, focuses on female victims, more recent research underscores those who occupy more marginalized identities, including trans or gender non-binary identities, and it shows that they're at disproportionately greater risk of experiencing sexual assault than their cisgender counterparts. So I just, as such, it's imperative that legislation not assert gender binaries, as it's not inclusive to those who are most at risk for experiencing such violence. So not only is it inclusive, but it's also empirically supported. And these statutes should be a resource to all members of the public, regardless of gender. And so that is all I have to say in support of AB 214 this morning. Thank you.
Thank you so much for your testimony and support, Dr. Campy. BPS, are there other individuals in support on the phone?
Thank you. We will go with next caller with the last 3 digits of 318. Caller, please slowly state and spell your name for the record. You have 2 minutes to speak and may begin.
Good morning, Chair Yeager and members of the Assembly Judiciary. This is Kendra Birchie, Kendra Bertschy, with the Washoe County Public Defender's Office. First, I want to thank the Assemblywoman as well as Ms. Evans for bringing forward this very important bill. We appreciate having the opportunity to work with them on this issue during the interim and really appreciate them bringing forward this language. As we all know, language and words that we use are extremely important, and gender-neutral language assists to reduce the stigma for victims of sexual assault. I unfortunately have represented many men and women who themselves were victims and used substances or failed to use services which led them into being criminal defendants under our care. It is all too common for our clients to disclose for the first time when appearing as a defendant to indicate that they too had been victimized. We hope that this will help break that cycle to provide all victims with services regardless of their gender. Thank you.
Thank you for your testimony, Ms. Birchie. BPS, if there are other callers in support, could we go to the next one, please?
Yes, next caller with the last three of 080, please slowly state and spell your name for the record. You have 2 minutes and may begin.
Hi, Jim Hoffman, representing Nevada Attorneys for Criminal Justice. I would like to echo the testimony from the presenters and from the other people who spoke. NACJ supports this because in general, we support, if you're dealing with crime through the criminal justice system, you've already failed in some sense. The best thing to do is to try and prevent crime from happening. As Ms. Birchie said, previously being victimized is one of the main predictors of someone going on to victimize someone else. And we believe that by helping victims and by making the system more inclusive of all victims, we're not just helping those victims, which is very important, we're helping to break this cycle. So again, we're thankful for this bill. We support this bill. Thank you.
Thank you for your testimony, Mr. Hoffman. VPS, could we see if there are other callers in support?
Yes, thank you. Next caller with the last three digits of 611. Please slowly state and spell your name for the record. You have 2 minutes to speak and may begin.
Good morning, Chairman Yeager and members of the Assembly Judiciary Committee. This is John Piro, John-Piro, from the Clark County Public Defender's Office. We'd like to thank the bill's sponsor for bringing this bill forward and speaking with us during the interim about this issue. We recognize at the Public Defender's Office the value of all human beings and that the change in language in this bill brings forward hope that this language will help survivors feel comfortable coming forward. And we urge the passage of this bill. Thank you.
Thank you for your testimony, Mr. Piro. BPS, do we have other callers in support?
Yes. Next caller with the last three digits of 648. Caller with the last three digits of 648, please press *6 to begin your testimony. Caller, please slowly state and spell your name for the record. You have 2 minutes and may begin.
Thank you, Chair Yeager, members of the Assembly Judiciary Committee. My name is John Jones, John Jones, here on behalf of the Nevada District Attorneys Association and the Clark County District Attorney's Office. We are here in support of AB 214, and we support efforts to de-gender our statutes in an effort to be more inclusive. I want to thank Assemblywoman Considine, who reached out well before this session to discuss this bill with us. I also want to thank her for the amendment, which is posted on Nellis, which we feel provides a more clarity. The original draft read a bit confusing as the person referred to the defendant and that person referred to the victim. The amendment that she filed this morning makes the statute a bit more clear. And I also want to reiterate the intent of this bill is not to change any of the elements of the current sexual assault statute. It is simply to de-gender the language contained within it. With that, Mr. Chairman, we want to reiterate our support of AB 214 and thank you for your time.
Thank you for your testimony, Mr. Jones. BPS, are there other callers in support?
For callers wishing to provide testimony in support of Assembly Bill 214, please press *9 now to take your place in the queue. Caller with the last three digits of 245. Caller, please slowly state and spell your name for the record. You have 2 minutes and may begin.
Good morning. This is Danielle Staple, Daniele, Staple. I'm the Executive Director for the Rape Crisis Center in Southern Nevada and want to speak in support of this bill. I want to thank the committee for hearing it so promptly and Assemblywoman Considine for bringing it forward, and the coalition for all their work representing the task force that Ms. Evans mentioned that have been working on the bill prior to session. The Rape Crisis Center feels this kind of language change is critically important. As Dr. Campy said, we know that transgender individuals, I'm sorry for that misspoke, are disproportionately impacted by sexual violence. And so having the statute correctly represent and be gender neutral so that all potential survivors and victims feel comfortable coming forward for services and to receive the justice they so richly deserve is critically important in our statutes. And we are wholeheartedly in support of this bill.
Thank you for your testimony, Ms. Staple. BPS, are there other callers in support?
For callers wishing to testify in support of Assembly Bill 214, please press star 9 now to take your place in the queue. Chair, there are no further callers in support at this time.
Thank you, BPS. I will close testimony in support. I will now open it up for testimony in opposition. I don't think there's anyone on the Zoom in opposition, but if I'm incorrect about that, please turn your camera on, unmute yourself, and let me know you'd like to testify. I don't see anyone joining us on the Zoom. BPS, could we go to the phone lines to see if there's anybody there in opposition?
Thank you, Chair. For callers wishing to testify in opposition of Assembly Bill 214, please press star 9 now to take your place in the queue. For callers wishing to testify in opposition of Assembly Bill 214, please press star 9 now to take your place in the queue. Chair, we do not have any callers in opposition at this time.
Thank you, BPS. I will close opposition testimony. I will now open neutral testimony. I don't believe we have anyone on the Zoom in neutral, but if I'm incorrect, please let me know by unmuting yourself and indicating you'd like to testify. I don't see anyone on the Zoom. BPS, let's check the phones, please, to see if there's anybody there in neutral.
Thank you. For callers wishing to testify in neutral of Assembly Bill 214, please press star 9 now to take your place in the queue. For callers wishing to testify in neutral of Assembly Bill 214, please press star 9 now to take your place in the queue. Chair, the public line is open and working. There are no callers for neutral at this time.
Thank you so much, BPS. I will close neutral testimony. Assemblywoman Considine, I'll turn it back over to you for you and Ms. Evans for any concluding remarks you might have on Assembly Bill 214.
Thank you very much, Chair, and thank you, committee. I really appreciate this. This is my first bill hearing, and I'm grateful for your time, your patience with this bill, and the support of everyone who worked on this bill, especially Serena Evans and Connie Monk. And Serena, if you wanted to follow up with anything, please feel free.
I will just keep it brief and say thank you so much for hearing this bill so fast. And thank you to Assemblywoman Considine as well as prior Assemblywoman Connie Monk for getting this conversation started. We're really excited to continue this work throughout Nevada.
Thank you so much, Assemblywoman Considine. I think that for a first bill hearing, that went pretty well. Only supportive testimony, no opposition, and no neutral. So you can pat yourself on the back, and I think that is a testament to the work that you've done on this piece of legislation, and I really appreciate that. I believe you reached out to me, I don't know how long ago it was, months and months ago, to talk about this. So I want to thank you, everyone who's worked on this piece of legislation, including our former colleague, Assemblywoman Monk. And we look forward to having you back in the Assembly Judiciary Committee at some point later this session, Assemblywoman Considine. Thanks for joining us, and have a great rest of the day. So I will now close the hearing on Assembly Bill 214. And committee, we are going to move on to our work session. And I should note for the record, Assemblyman O'Neill has joined us. He did join us partway through that last bill hearing. So I think we have everyone present. Assemblywoman Summers Armstrong might have stepped away for a moment, but I expect her to be back shortly. And given the number of folks that we have on the Zoom that are interested in this work session, I'd like to take us to the work session now. But before we do, I did just want to ask the individuals that we have on the work session, on the Zoom with us for the work session, if you could do me a favor after the bill that you're interested in, after we process that bill and move on, if you could log off of the Zoom, that'll help us with our bandwidth, and it'll help me hopefully get all of the members on one screen at one time. So with that, committee members, the work session document is up on Nellis, and members of the public, the document is up on Nellis as well. We'll process this work session much like we did last week's, where Ms. Thornton will read the description of the bill under consideration. We'll then have a time for questions. We'll take a motion, have any comments, and then vote. And after that, I will assign a floor statement. So Ms. Thornton, why don't we start? Why don't we just plan to take the bills in order? If you want to take us through Assembly Bill 25, please.
Thank you, Chair. Diane Thornton, again for the record. Assembly Bill 25 was sponsored by this committee on behalf of the Division of Public and Behavioral Health and heard on February 18th. This bill revises provisions relating to the conditional release of certain persons found to be incompetent. There is one amendment to the measure. It was proposed by Jim Hoffman, Nevada Attorneys for Criminal Justice. And Mr. Hoffman did work with Dr. Neighbors from the Public and Behavioral Health, the Division of, on the amendment, and they are in agreement with it. The first changes must to may in Section 1 concerning law enforcement taking the person into protective custody. The second changes from 10 to 3 days when the court must hold a hearing. And lastly, it allows the hearing to be continued up to 10 days upon agreement by both parties. Thank you, Chairman.
Thank you, Ms. Thornton. I want to thank Dr. Neighbors and Mr. Hoffman for working on this bill. You may recall during the hearing there were some concerns about some of the timeframes in there, but I am happy to report that there was a consensus reached from the bill sponsor and those proposing the amendments. Does anybody have questions about Assembly Bill 25 as detailed in the work session document? Okay, I don't see questions, so at this time I would be looking for a motion to amend and do pass.
I'd move to amend and do pass.
Seconded, Mr. Chairman.
Okay, so we have a motion to amend and do pass from Vice Chair Nguyen. We have a second from Assemblyman Wheeler. Is there any discussion on the motion before we take the vote? Okay, I don't see discussion on the motion. And again, members will be doing a roll call vote to make sure the record is clear. So if you are in favor, please indicate by saying yes. If you are opposed, please say no. Madam Secretary, would you please call the roll on Assembly Bill 25?
Assemblywoman Bilbray Axelrod.
Yes.
Assemblywoman Cohen.
Yes.
Assemblywoman Gonzalez.
Yes.
Assemblywoman Hanson.
Yes.
Assemblywoman Hardy.
Yes.
Assemblywoman Kasama. Assemblywoman Krasner.
Sorry. Yes. Yes.
Assemblywoman Krasner.
Yes.
Assemblywoman Marzola.
Yes.
Assemblyman Miller.
Yes.
Assemblywoman Nguyen.
Yes.
Assemblyman O'Neill.
Yes.
Assemblyman Orntlicker.
Yes.
Assemblywoman Summers Armstrong.
Yes.
Assemblyman Wheeler.
Yes.
Chairman Yeager.
Yes. So that motion does pass. It was unanimous. That is a great start to our work session committee. And I'm going to assign the floor statement on Assembly Bill 25 to Assemblyman Wheeler. Ms. Thornton, let's go to Assembly Bill 33 next.
Thank you, Chair. Assembly Bill 33 was sponsored by this committee on behalf of the Nevada Association of Counties and heard in committee on March 5th. This bill provides that the process for establishing the paternity of a child be legally established during a civil proceeding concerning the protection of a child. There is one amendment proposed by Dagny Stapleton, the Executive Director of NACO. First, it deletes several sections of the bill, including 1 through 11, 13, and 14. It amends Section 12 of the bill by adding a reference to Chapter 432B. Adds a new section, Section 13, amending NRS 126.091, which is jurisdiction and venue. And lastly, Chair, it amends NRS 126.161 to provide that a judgment or order issued pursuant to Chapter 126 within an NRS 432B proceeding is excluded from the confidentiality provisions, and also a judgment or order issued pursuant to Chapter 126 within an NRS 432B proceeding is considered a final order. Thank you, Chair.
Thank you, Ms. Thornton. And Assemblywoman Krasner had indicated to me that she had a question on this bill. So Assemblywoman, we'll give you a chance to ask that question. And then I believe we have Ms. Lucy on with us who will be able to answer that question.
Thank you, Chair Yeager. During the committee hearing on this bill, they talked about creating a final amendment that allowed for the right to appeal. Was that included in the amendment? Thank you.
Through the Chair Yeager to Assemblyperson Krasner, Megan Lucy, MEGANLUCEY, on behalf of Washoe County Human Services Agency. Yes, Madam Chairman, on the amendment to the proposed 126.0191 and 161, if you look at number 4 on the new changes, you'll see that sub 2 states a judgment or order shall issue pursuant to chapters 126 of NRS within NRS 432B proceeding is considered a final order. That language specifically addresses the appealable issue because all final orders are appealable. And that was a concern that was brought up through the stakeholders and was addressed specifically with that provision. So yes, these orders will be appealable.
Thank you.
Thank you, Assemblywoman Krasner. Are there other questions from committee members on Assembly Bill 33 as detailed in the work session document? Doesn't look like we have other questions. So at this time, I would be looking for a motion to amend and do pass Assembly Bill 33.
I would move to amend and do pass Assembly Bill 33.
Who would like to second?
I'll second.
Okay, so we have an amend and do pass motion from Vice Chair Wynn. We have a second from Assemblyman O'Neill. Is there any discussion on the motion? Before we vote, I just want to say thank you. I know this was a lot of work and a long time coming, so appreciate the interested parties who worked on this legislation. Thank you for putting the time in. And again, we'll take a roll call vote on Assembly Bill 33. Madam Secretary, if you could please call the roll.
Assemblywoman Bilbray Axelrod.
Yes.
Assemblywoman Cohen.
Yes.
Assemblywoman Gonzalez.
Yes.
Assemblywoman Hanson.
Yes.
Assemblywoman Hardy.
Yes.
Assemblywoman Kasama.
Yes.
Assemblywoman Krasner.
Yes.
Assemblywoman Marzola.
Yes.
Assemblyman Miller.
Yes. Yes.
Assemblywoman Wynn.
Yes.
Assemblyman O'Neill.
Yes.
Assemblyman Orntlicker.
Yes.
Assemblywoman Summers Armstrong.
Yes.
Assemblyman Wheeler.
Yes.
Chairman Yeager.
Yes, the motion does pass unanimously. I'm going to assign the floor statement on Assembly Bill 33 to Assemblyman Miller. Ms. Thornton, let's go next to Assembly Bill 60, please.
Assembly Bill 60 was sponsored by this committee on behalf of the Attorney General and heard in committee on February 16th. This bill makes certain provisions of a contract or settlement agreement void and unenforceable. There are two amendments to this measure. First, Kyle George from the Office of the Attorney General proposed an amendment to add additional protected classes, including race, religious creed, color, national origin, disability, sexual orientation, gender identity or expression, ancestry, and familial status to the bill. And secondly, Assemblywoman Summers Armstrong proposed to add age in addition to the list above. Thank you, Chairman.
Thank you, Ms. Thornton. Are there any questions about Assembly Bill 60 as detailed in the work session document? I'm not seeing any questions, I don't believe, but let me just take one more look. Okay, I don't see questions, so at this time I'd be looking for a motion to amend and do pass Assembly Bill 60.
I would move to amend and do pass Assembly Bill 60.
Do we have a second?
Second.
So we have a motion to amend and do pass from Vice Chair Wynn. We have a second from Assemblywoman Bilbray Axelrod. Is there any discussion on the motion? I don't see any discussion. Madam Secretary, would you please do the roll call vote for Assembly Bill 60?
Assemblywoman Bilbray Axelrod.
Yes.
Assemblywoman Cohen.
Yes.
Assemblywoman Gonzalez.
Yes.
Assemblywoman Hanson.
Yes.
Assemblywoman Hardy.
Yes.
Assemblywoman Kasama.
Yes.
Assemblywoman Krasner.
Yes.
Assemblywoman Marzola.
Yes.
Assemblyman Miller.
Yes.
Assemblywoman Wynn.
Yes.
Assemblyman O'Neill.
Yes.
Assemblyman Orentlicker.
Yes.
Assemblywoman Summers Armstrong.
Yes.
Assemblyman Wheeler.
Yes.
Chairman Yeager.
Yes. The motion carries unanimously. I will assign the floor statement on Assembly Bill 60 to Assemblywoman Summers Armstrong. Ms. Thornton, let's go next to Assembly Bill 64, please.
Yes, Chairman. Assembly Bill 64 was sponsored by this committee on behalf of the Attorney General and heard in committee on March 8th. This bill changes the penalties for certain unlawful acts relating to preventing or dissuading certain persons from testifying or producing evidence. The definition of soliciting a child for prostitution is also revised. There's one amendment from Jessica Adair, Chief of Staff, Attorney General's Office. The amendment does the following. First, it strikes new language and reverts back to existing law in subsection 1 and 2 of section 1, subsections 2C through 11, and also in section 5. It adds a new section 3, amending NRS 201.354, providing that the Attorney General has concurrent jurisdiction with the district attorneys in the state to prosecute violations of facilitating sex trafficking and engaging in prostitution or solicitation for prostitution. And lastly, it revises the definition of the crime soliciting of a child for prostitution. Thank you, Chairman.
Thank you, Ms. Thornton. Are there any questions about Assembly Bill 64 as detailed in the work session document? I don't see any questions. Oh, maybe there is one. Assemblywoman Summers Armstrong, please go ahead.
I just wanted to know if someone could explain why we went back to some of the original language, if we could have a quick recap.
Thank you, Assemblywoman. I do believe the language in the amendment was the language that was presented at the hearing, but we do have Ms. Adair and Mr. George with us on the Zoom. If one of you would like to take that question and try to answer as succinctly as you can, please.
Hi, Jessica Adair for the record. Yes, Chair, you are correct. The amendment that Ms. Thornton read just now in presenting the bill was the amendment that we presented in the hearing on this bill. And if there are specific sections on the amendment that you would like me to go through, I can. In terms of the witness dissuasion section, we decided to go back to the original statutory language after some concerns from stakeholders regarding the practicality of that section. We also, in terms of the advertising advertising for prostitution, we reverted back to the original statutory language regarding some constitutionality and practicality of that for legal brothels. And if you have any other specific questions about other sections of the bill, I'm happy to take those.
Thank you, Chairman Yeager, Ms. Adair. That clarifies, and I appreciate the explanation.
You are very welcome. Are there any other questions about Assembly Bill 64 as detailed on the work session document? Okay, seeing no additional questions, I would be looking for a motion to amend and do pass on Assembly Bill 64.
I'd move to amend and do pass Assembly Bill 64.
Who'd like to second? Assemblywoman Krasner, do you want to make the second?
I second the motion.
Great, thank you. So we have a motion to amend and do pass from Vice Chair Wynn, a second from Assemblywoman Krasner. Any discussion on the motion? I don't see any discussion on the motion. Madam Secretary, would you please take a roll call vote on the motion for Assembly Bill 64?
Assemblywoman Bilbray Axelrod,
Yes.
Assemblywoman Cohen,
Yes.
Assemblywoman Gonzalez,
Yes.
Assemblywoman Hanson,
Yes.
Assemblywoman Hardy,
Yes.
Assemblywoman Kasama,
Yes.
Assemblywoman Krasner,
Yes.
Assemblywoman Marzola,
Yes.
Assemblyman Miller,
Yes.
Assemblywoman Wynn,
Yes.
Assemblyman O'Neill,
Yes.
Assemblyman Orentlicker,
Yes.
Assemblywoman Summers Armstrong,
Yes.
Assemblyman Wheeler,
Yes.
Chairman Yeager.
Yes. The motion passes unanimously. I will assign the floor statement on Assembly Bill 64 to Assemblywoman Krasner. Moving right along, Ms. Thornton, let's take Assembly Bill 115.
Thank you, Chairman. Assembly Bill 115 was sponsored by Assemblywoman Wynn and heard in committee on February 26th. This bill authorizes the court to determine in certain circumstances that more than two people have a parent and child relationship with a child. There are three proposed amendments to this measure. First, Assemblywoman Wynn proposed an amendment that would do the following. First, it would delete provisions of the bill that would have amended or added to certain chapters of NRS pertaining specifically to Chapter 125C, Chapter 126, and Chapter 128. Deletes language that would have required the committee to review child support guidelines, to review the guidelines within 90 days of the effective date of the bill. And it adds and amends language to Chapter 127 of NRS regarding the adoption of minor children. Secondly, Assemblywoman Wynn and Kimberly Surratt proposed an amendment that adds language to Chapter 127 of NRS to allow that if one of the petitioners is related within the third degree of consanguinity, that the court may, in its discretion, waive the hearing. And lastly, Assemblywoman Cohen proposed an amendment to revise the amendment in NRS 127.040 by deleting the or and replacing with it and. Thank you, Chairman.
Thank you, Ms. Thornton. Any questions on Assembly Bill 115 as detailed in the work session document? I'm not seeing questions. I think I almost have all of you on one screen at this point. Almost. Okay, seeing no questions, I would be looking for a motion to amend and do pass Assembly Bill 115.
I would move to amend and do pass Assembly Bill 115.
Thank you. Who would like to second?
Second.
So I have a motion to amend and do pass from Vice Chair Wynn, a second from Assemblyman Miller. Any discussion on the motion? I don't see any discussion. Madam Secretary, would you please call the roll call vote for the motion to amend and do pass on Assembly Bill 115?
Assemblywoman Bilbray Axelrod,
Yes.
Assemblywoman Cohen,
Yes.
Assemblywoman Gonzalez,
Yes.
Assemblywoman Hanson,
Yes.
Assemblywoman Hardy,
Yes.
Assemblywoman Kasama,
Yes.
Assemblywoman Krasner,
Yes.
Assemblywoman Marzola,
Yes.
Assemblyman Miller,
Yes.
Assemblywoman Wynn,
Yes.
Assemblyman O'Neill,
Yes.
Assemblyman Orentlicker,
Yes.
Assemblywoman Summers Armstrong,
Yes.
Assemblyman Wheeler,
Yes.
Chairman Yeager.
Yes, motion carries unanimously. I will assign the floor statement to Vice Chair Wynn. Ms. Thornton, let's go next to Assembly Bill 145, please.
Assembly Bill 145 was sponsored by Assemblywoman Cohen and heard in committee on March 2nd. This bill adopts the Uniform Registration of the Canadian Money Judgments Act, and there are no amendments for this measure. Thank you, Chair.
Thank you so much, Ms. Thornton. Are there any questions about Assembly Bill 145 as detailed in the work session document? Don't see any questions, so at this time I'd be looking for a motion to do pass Assembly Bill 145.
I'd move to do pass. Oops. I'll second Assemblyman Wheeler's.
That was close. A lot of activity on the Canadian money judgment bill. So we're going to give the motion to do pass to Assemblyman Wheeler. Give the second to Vice Chair Wynn. Is there any discussion on the motion? Seeing no discussion, Madam Chair, would you please conduct the roll call vote?
Assemblywoman Bilbray Axelrod,
Yes.
Assemblywoman Cohen,
Yes.
Assemblywoman Gonzalez,
Yes.
Assemblywoman Hanson,
Yes.
Assemblywoman Hardy,
Yes.
Assemblywoman Kasama,
Yes.
Assemblywoman Krasner,
Yes.
Assemblywoman Marzola,
Yes.
Assemblyman Miller,
Yes.
Assemblywoman Wynn,
Yes.
Assemblyman O'Neill,
Yes.
Assemblyman Orentlicker,
Yes.
Assemblywoman Summers Armstrong,
Yes.
Assemblyman Wheeler,
Yes.
Chairman Yeager.
Yes, motion carries unanimously. Thank you, Madam Secretary. I will assign the floor statement to Assemblywoman Cohen. Committee members, we just have a few more to go. Ms. Thornton, could we take Assembly Bill 151 next?
Assembly Bill 151, sponsored by Assemblywoman Gonzalez and heard in this committee on February 25th. This bill removes the authority of the court to suspend the driver's license of a defendant or prohibit a defendant from applying for a driver's license for a specified period if the delinquent fine, administrative assessment, fee, or restitution was originally imposed for a minor traffic offense. There is an amendment proposed by Assemblywoman Gonzalez, and she's proposing to add co-sponsors to the bill. Thank you, Chairman.
Thank you so much, Ms. Thornton. Are there any questions on Assembly Bill 151 as detailed in the work session document? Assemblywoman Hanson?
Thank you, Chair. I haven't gotten any clarity yet on this.
Is insurance, when you drive without insurance, is that classified as a minor traffic offense? Because I know that's what we're dealing with in this proposed legislation is minor traffic offenses. So I just was curious. I tried to look it up myself, but those of you more familiar with the law might be able to enlighten me.
Thank you for the question. So it's an interesting question. There's a couple different parts to it. Driving with insurance is considered a minor traffic offense, but if you drive without insurance, this bill in front of you is not going to prevent your driving privileges from being suspended, because the fact of not having insurance is going to get your driver's license suspended. So I don't want to leave the impression that you can drive without insurance and you'll just be able to drive. What this bill does is it says if you don't take care of your fines and fees, or if you don't appear in court, they can't suspend your driver's license for that reason. But driving without insurance in and of itself is something that will get you suspended. And I don't know if any of you have had this experience, but sometimes there's a lack of communication between your insurance company and the DMV, and you'll get a notice from the DMV that they don't have updated insurance information. If you don't provide that, your license will be suspended. So to answer your question, it is considered already an existing statute, a minor traffic offense, but this bill doesn't really speak to that particular offense because it would still be a suspendable offense. Hopefully that answers your question.
Oh, that did, very much so. Thank you.
You're welcome. Assemblywoman Summers Armstrong.
Thank you, Chair Yeager. I would like, if this is, could I have an opportunity to sign on to this bill at this time? Is that appropriate?
Yeah, we can incorporate that into the amendment that's going to be made, Assemblywoman Summers Armstrong. So yes, we can do that. That's an easy one, thankfully.
Thank you, Chair.
Are there other questions about Assembly Bill 151 as detailed on the work session document? Assemblywoman Kasama?
I'm making sure I've got my unmute button ready now. So my question is, if you can just refresh, this is a good bill. I like this bill. If you could just refresh my memory. If a person, I don't think anybody should go to jail for minor traffic violations, but if they continue to rack them up and don't do anything, is community service mandatory, or how do we address somebody that just doesn't do anything about this, since we've removed incarceration, which is, I think, a good thing, but how do we, how are we addressing that if somebody doesn't just deal with it at all?
We have Ms. Mosley with us on the Zoom, who was one of the co-presenters with Assemblywoman Gonzalez. So I think I'd probably ask her to address that. And if you could be as succinct as possible, that would be appreciated.
Thank you, Chair. Thank you, Chair Yeager. Lisa Mosley. Assemblywoman Kasama, there is already provisions in the law that allow for civil judgments. The only thing this bill would do was prevent anyone from having their driver license suspended for non-payment, but the law currently allows for civil judgments. And so that, I believe that's what would happen. If they continue to rack those up, that would just become a civil judgment against them.
Thank you so much. Appreciate it.
You're welcome.
And, one thing I'll add, we didn't really talk about this at the hearing, but this concern about, maybe there are folks out there who are just going to sort of game the system, right? They're not going to pay, they're not going to do community service, and their licenses won't be suspended. I'll just make a couple of notes. Number one, if you're a bad driver, the DMV is still getting information about your ticket. So your driver's license can be suspended, or your insurance is going to go up if you get too many points due to your driving. And the other thing I would say is, a court has contempt power. So if somebody, truly is in a position to do the community service and just doesn't do it, the court would have the ability to hold that person in contempt in some fashion, because essentially you're violating a court order. The court is telling you have to do community service and you're not doing it. There's some protections that go along with that process. You get an attorney, but so the court does have at its disposal things that it can do if there are people that just are not taking their obligations seriously and disregarding what they should be doing. This bill simply speaks about the driver's license suspension piece that comes out of that. And hopefully that's some clarifying information without going too far down the rabbit hole.
Extremely helpful. Thank you.
You're welcome. And thank you for answering that question, Ms. Mosley. Any other questions on Assembly Bill 151 as detailed in the work session document? Okay, seeing no questions at this time, I'll take a motion to amend and do pass Assembly Bill 151 with the caveat that we're going to add Assemblywoman Summers Armstrong as co-sponsor as well.
I would move to amend and do pass Assembly Bill 151.
And I'll second that.
Okay, so we have a motion from Vice Chair Wynn. As motion is to amend and do pass with that one additional provision to add Assemblywoman Summers Armstrong as a co-sponsor. The second is from Assemblywoman Kasama. Is there any discussion on the motion in front of the committee? Assemblywoman Hanson, and then we'll go to Assemblywoman Krasner.
Thank you, Chair. I like so much of this bill and agree with the intent. And I'm a yes, but I will reserve my right. Could maybe clarify just one or two more things that I need to resolve. I really do like the Texas and the Arizona models. That gave me a lot of comfort worrying about the revenue side of things and seeing some good outcomes. So again, I'm a yes, but I'll reserve my right just to clarify a couple things before.
Thank you so much, Assemblywoman Hanson. Assemblywoman Krasner?
Oh, thank you, Chair Yeager. I do like several portions of the bill. I have some concerns with the fact that there's no penalty for failure to appear. I know in some other countries there's no penalty for failure to appear, and citizens are allowed to thumb their nose at please district attorney courts. I don't know if we want to go down that rabbit hole, but I'll vote yes to get it out of committee and reserve my right to change Paragraph 4. Thank you.
Thank you so much. Are there any other discussion? I see we have Assemblyman O'Neill. Please go ahead.
Thank you, Chair. Have some concerns, but I will vote yes, but I'll reserve my right for the floor vote to change, please. Thank you.
You're welcome, Assemblyman O'Neill. Assemblywoman Hardy?
Thank you, Chair. I too think this is a good bill. I just want to clarify some concerns myself, so I'll vote yes out of committee and reserve my right. Thank you.
Thank you, Assemblywoman Hanson. Are there any other discussion on the motion? Great, and I'll remind members that you always reserve your right. You can always change your mind between the committee vote and the floor vote. I would just ask, as a matter of courtesy, if you could let me know if you're going to do that. Helps me plan for how much time we might need on the assembly floor for bills. But as elected members, you always have the right to do that. Okay, seeing no additional comments on the motion, Madam Secretary, would you please conduct a roll call vote on motion to amend and do pass Assembly Bill 151?
Assemblywoman Bilbray Axelrod?
Yes.
Assemblywoman Cohen?
Yes.
Assemblywoman Gonzalez?
Yes.
Assemblywoman Hanson?
Yes.
Assemblywoman Hardy?
Yes.
Assemblywoman Kasama?
Yes.
Assemblywoman Krasner?
Yes.
Assemblywoman Marzola?
Yes.
Assemblyman Miller?
Yes.
Assemblywoman Wynn?
Yes.
Assemblyman O'Neill?
Yes.
Assemblyman Orentlicker?
Yes.
Assemblywoman Summers Armstrong?
Yes.
Assemblyman Wheeler?
No.
Chairman Yeager?
Yes, the motion does carry. I believe the vote was 14 yeses, 1 no, with Assemblyman Wheeler as the sole no on the bill. Again, the motion does pass. I'm going to assign the floor statement to Assemblywoman Gonzalez. Ms. Thornton, let's take our second to last bill, Assembly Bill 157.
Assembly Bill 157 is sponsored by Assemblywoman Monroe Moreno and heard in committee on March 3rd. This bill authorizes a person who is a victim of certain discriminatory conduct relating to an incident involving a peace officer to bring a civil action under certain circumstances. There is an amendment to the bill proposed by Assemblywoman Danielle Monroe Moreno. First, she is proposing to add a co-sponsor of the bill. Secondly, she adds language without reasonable cause to the bill regarding a person that may bring a civil action for damages. Thank you, Chairman.
Thank you, Ms. Thornton. Any questions for Assembly Bill 157 as detailed in the work session document? Assemblyman O'Neill?
Thank you, Mr. Chair. I just want to say I was initially opposed to this bill, but I really want to thank Ms. Monroe Marino for the small amendment change. It makes a world of difference to me on consideration of the bill. So I just wanted to extend my appreciation and thank you.
Thank you, Assemblyman O'Neill. Any other questions about Assembly Bill 157? Assemblyman Wheeler?
Thank you, Mr. Chairman. I was very worried that this bill also would cause people not to call the police, although I do see the need for the bill itself. But I want to thank the Assemblywoman Monroe Moreno for the amendment and bringing me over to the other side. So I'm going to go yes on it.
Thank you, Assemblyman Wheeler. Other questions about Assembly Bill 157? Okay, I don't see questions. At this time, I will go to Assemblyman Miller, who I believe would like to make a motion.
I'd like to motion to amend and do pass AB 157.
Thank you, Assemblyman Miller, and we have a second. So Assemblyman Miller has made the motion to amend and do pass. We have a second from Assemblywoman Bilbray Axelrod. Any additional comments on the motion? Seeing no additional comments, Madam Secretary, would you please conduct the roll call vote?
Assemblywoman Bilbray Axelrod?
Yes.
Assemblywoman Cohen?
Yes.
Assemblywoman Gonzalez? Assemblywoman Hanson?
Yes.
Assemblywoman Hardy?
Yes.
Assemblywoman Kasama?
Yes.
Assemblywoman Krasner?
Yes.
Assemblywoman Marzola?
Yes.
Assemblyman Miller?
Yes.
Assemblywoman Wynn?
Yes.
Assemblyman O'Neill?
Yes.
Assemblyman Orentlicker?
Yes.
Assemblywoman Summers Armstrong?
Yes.
Assemblyman Wheeler?
Yes.
Chairman Yeager?
Yes, the motion passes unanimously. I will assign the floor statement to Assemblyman Miller. Ms. Thornton, let's take the last bill on the work session document, Assembly Bill 202.
Thank you, Chairman. Assembly Bill 202 was sponsored by Assemblyman Yeager and heard in committee on March 11th. This bill revises provisions relating to charitable lotteries and charitable games, and there is one amendment proposed by Michael Morton from the Nevada Gaming Control Board. His amendment provides that a qualified organization that offers prizes under $100,000 annually would have to register with the Gaming Control Board as a qualified organization once per year and pay the annual fee of $10. Thank you, Chairman.
Thank you, Ms. Thornton. And before I take questions, I'll just take a moment to explain that additional amendment. In consultation with Mr. Morton at the Gaming Control Board, we decided it probably didn't make sense to have an organization only have to pay one fee, but have to register for each separate charitable event that they were doing. So the amendment in front of you basically says they just have to register one time and pay one fee, and that'll cover them for the entire year. So it should save on some paperwork from the qualified organizations as well as the Gaming Control Board side. Any questions about Assembly Bill 202 as detailed in the work session document? Don't see questions. At this time, I take a motion to amend and do pass.
I'd move to amend and do pass.
Do we have a second?
I second.
So I have a motion to amend and do pass from Vice Chair Wynn. We have a second from Assemblywoman Marzola. Any discussion on the motion? Seeing no discussion, Madam Secretary, would you please conduct the roll call vote?
Assemblywoman Bilbray Axelrod?
Yes.
Assemblywoman Cohen?
Yep.
Assemblywoman Gonzalez?
Yes.
Assemblywoman Hanson?
Yes.
Assemblywoman Hardy,
Yes.
Assemblywoman Kasama,
Yes.
Assemblywoman Krasner,
Yes.
Assemblywoman Marzola,
Yes.
Assemblyman Miller,
Yes.
Assemblywoman Wynne,
Yes.
Assemblyman O'Neill,
Yes.
Assemblyman Orentlicker,
Yes.
Assemblywoman Summers Armstrong,
Yes.
Assemblyman Wheeler,
Yes.
Chairman Yeager.
Yes, the motion does carry unanimously. I will take the floor statement on that one. Thank you, Ms. Thornton and committee members, for getting us through that work session. Thank you for those who joined us on the Zoom to answer questions. With the work session behind us, we have yet another bill on the agenda, and I will be presenting that bill with a couple others. So at this time, I'm going to hand the virtual gavel over to Vice Chair Wynne.
Thank you. And at this time, I will open the hearing on Assembly Bill 219. This bill revises provisions governing the sealing of criminal records. Assemblyman Yeager, please begin when you are ready.
Thank you so much, and good morning, Madam Vice Chair and members of the Assembly Judiciary Committee. For the record, I am Assemblyman Steve Yeager, representing District 9 in Southwest Las Vegas. It is an honor this morning to present to you Assembly Bill 219. With me today is Sophia Romero, an attorney with the Legal Aid Center of Southern Nevada, and Bailey Bordelin with the Nevada Coalition of Legal Services Providers. With the Vice Chair's permission, I intend to give some brief opening remarks, and then Ms. Bordelin can take you through the bill. There is one conceptual amendment that I've provided to the committee. You can find it on Nellis. Thankfully, it's not overly complicated and doesn't do too much to change the bill. Assembly Bill 219 is intended to improve the record sealing process to allow greater access to justice. For those of you who have served on this committee over the past few sessions, you've heard that record sealing can be an extremely difficult, burdensome, and daunting process. Many interested persons in the community, including the Boyd School of Law, the Public Defender's Office, and legal aid providers all work tirelessly to make sure that record sealing is as accessible as possible, and they assist community members with the process. But to be honest, there are still major barriers in having your record sealed. Assembly Bill 219 does three things to make this process a little easier. One, it streamlines record sealing for people who have received a pardon. Two, it clarifies the role of the prosecuting attorney in the record sealing process. And three, it allows a petitioner to appeal a court's denial to seal a record. With respect to pardons, currently receiving a pardon does not automatically seal your criminal record. Right now, it's a painstaking and confusing process for someone to seal their record after they were granted a pardon. And to be honest, many people who are pardoned have no idea that their records are not automatically sealed. I personally believe that a pardon should be an indication that this person is eligible for a record sealing, and the petitioner, the courts, and all parties involved shouldn't have to expend resources to relitigate the record sealing issue when the person has already received a pardon. Additionally, we would like to fix some issues that have come up since we codified the presumption that criminal records in Nevada should be sealed. We codified that presumption in the 2017 legislative session. There have been some concerns with the statute being applied differently in different parts of the state, and we want to close those loopholes as well as modernize the appeal language. Currently, and you'll find this in the amendment, a petitioner can apply for 2 rehearings in front of the court, but they can't appeal the decision. The rehearing language, having 2 rehearings, doesn't appear anywhere else in statute and is unlikely to change the outcome of the proceeding. So instead, we're proposing to delete the 2 rehearing option, and instead just note that if your petition is denied, you would have the right to appeal it as you would any other final order, so that an appellate court can review the denial. With that, Madam Vice Chair, I'd like to turn it over to Ms. Bordelin, who will take you through the sections of the bill, and then we'll be available to answer any questions the committee may have.
Please proceed.
Good morning. Thank you for having me, Bailey Bordelin, for the record with the Nevada Coalition of Legal Service Providers. Thank you to Vice Chair and the committee and Chair Yeager for bringing this bill. As Chair Yeager pointed out, the record sealing process can be extremely burdensome and arduous, and I appreciate Chair Yeager always working to turn the slow wheels of justice to improve the process. So we are back again with a few more fixes. I'm going to walk you through the bill piece by piece. So if you'll look at Section 1, it requires the court to grant the record sealing petition without relitigating the merit for someone who has received a pardon from the State Board of Pardons Commissioners. This not only eliminates the burden on the petitioner, but all of the parties that expend resources in this process. As Chair Yeager mentioned, there is some confusion that people don't realize that a pardon is different from the record sealing process and that one doesn't necessarily accompany the other. So a problem we do run into in this area is that people assume their records have been sealed, and it becomes a problem when they then don't think they need to disclose it, or it still shows up on a background check and it's something that they're unaware of. So going forward, under that subsection 1, the Pardons Board could send copies of the pardon to the court and central repository after the pardon has been granted. And if that happens, we'll just do an automatic sealing. For prior cases, or if that doesn't happen, subsection 2 lays out the process for the individual to initiate that record sealing process in a streamlined fashion. Sections 3, 4, and 5 clarify the law regarding what happens when the district attorney doesn't respond to a record sealing application. Right now, the statute is not clear on the role of the district attorney. If you look at Section 3, subsection 4, the law says that if the prosecuting attorney stipulates to the sealing, a hearing is not required, and the judge can just review that file and order the record sealed without a formal hearing. If the prosecuting attorney objects, a hearing must be conducted. The law doesn't say what happens if the prosecuting attorney doesn't respond, but it also doesn't specifically compel a response. So this has left cases in a precarious position in some of our courts in the state with no real statutory path forward. This bill will provide clarity by specifying that if the prosecuting attorney does not file a written objection within 10 days, then the court can proceed. I want to note that we are still talking about that timeline language, and we'll be working with stakeholders going forward after this hearing. The city of Henderson did reach out, and we're going to work with them on that timeline because the process works a little bit differently in municipal court than it does in district court. So in district court, the prosecuting attorney reviews the petition and decides whether or not to sign off before it's ever filed with the court. So for those that do end up getting set for a hearing, typically because the prosecutor did not sign off, we believe 10 days is a reasonable time frame to then file that objection because they know it's coming. But it's now my understanding that the process works differently in some municipal courts, and they actually don't see it until that first window of time when it has been set for a hearing. So we're going to work with them to make sure that we can remedy the issue and they have enough time to review. And I would note that the Washoe County DA's office has also asked to discuss that timeline. Section 5, subsection 7 will also streamline the process for someone who has been acquitted, for whom prosecution has been declined, or for whom charges were dropped, requiring that the court shall seal their records as well. And then lastly, for Section 6, I will refer you to the Conceptual Amendment Chairman Yeager has provided. This piece allows a person to appeal the decision if their petition is denied. So as he explained, we believe that these judicial decisions should be subject to a regular appeal as is standard in any area of law. So with that, we are available for any questions. Thank you.
Assemblyman Yeager, do you have any further statements, or are you ready for questions?
Thank you, Madam Vice Chair. Steve Yeager for the record. Given that it's Friday and we're a couple hours into the meeting, I think we're ready for questions.
Okay, I'm looking around. I haven't received any messages. Oh, I have Assemblyman O'Neill. Go ahead with your question, sir.
Thank you, Madam Chair, and I promise to make it quick. The discussion on calendar, or on the 10 days, calendar days, judicial days, or something else? That's all.
Thank you for the question, Bailey Bordelin for the record. I'm just pulling up the bill. I believe we specified calendar days. Oh, looks like we didn't. So we will make sure that it is calendar or judicial clearly when we rework that timeline.
Do you have any idea which way you'll go? I like judicial.
I believe we intended judicial, so we can make that note.
Excellent. Thank you very much. And if I may, Madam Chair,
Go ahead.
when I was working several years ago for the Department of Public Safety, the criminal history records was under my purview. And I will say this really was a problem on people did not know, and they were calling in complaining, thinking that they got a pardon and thinking that the record was sealed. So it really is a very decent bill, and I appreciate Chair Yeager bringing it forward. I just wish he'd asked if other people could sign on, because I'd like to have.
Steve Yeager for the record. Assemblyman, as you probably noticed, most of my bills, I haven't asked anyone to sign on because I've been rushing to get them down to the front desk, but certainly would welcome anyone else to sign on to the bill. Since we're going to be doing an amendment anyway, we can do that through the amendment process. So I'll add you, and if anyone else like to sign on, please just let me know. Looks like I see a number of hands, so I'll send out an email and I'll get everyone squared away before the hearing. Thank you.
We could go to Assemblywoman Leslie Cohen, please.
Thank you, Vice Chair. I would make a recommendation, just as a consideration, that instead of 10 judicial days, possibly consider doing the 14 calendar, like 8th Judicial District Court rules are moving toward, just to have, hopefully that will kind of get us some consistency and for practitioners.
Thank you, Assemblywoman Bailey Bordelin for the record. That was brought up that the civil rules of procedure do have that opposition 14-day timeline. So that was certainly something I was going to bring up when we meet with the stakeholders to see if we can all agree on a timeline.
Great, thanks.
Next up, we have Assemblywoman Hanson.
Thank you, Vice Chair, for the opportunity. And thank you for the bill and an opportunity to understand part. So in Section 1, when it talks about unconditional pardon versus in Section 1, Sub 2, just regular pardon, could you help me understand what the difference is? So if you have an unconditional, it'd be an automatic versus the regular pardon. What kinds of things make a pardon an unconditional versus conditional, I guess?
Thank you for the question, Bailey Bordelin for the record. You know, I am not a pardons attorney, so I'm not sure if Sophia Romero, who's on, knows the answer either, but if not, I believe we do have some criminal law attorneys that could speak to that either now or when they speak later on in the bill. And if you don't get an answer to that question, I will follow up with you.
The reason I'm asking is just so I can understand, you know, yes, it's important that it be an automatic sealing when it's unconditional, but when it's not, what kinds of crimes or issues are we considering when they're going to seek to ask for sealing, just out of curiosity?
Madam Vice Chair, this is Steve Yeager for the record. I believe we have Ms. Christina Wildeveld with us on the Zoom. She might just be with us by audio. I think she intended to give some type of testimony on the bill, but she probably does more pardon work than anybody else in the state. So if you would allow her and she's available, she may be able to answer that question.
I did see her on there. Thank you for pointing that out, Assemblyman Yeager. Ms. Wildeveld, I see you on our Zoom. Is it possible for you to unmute and maybe you can answer that question?
Thank you, Assemblywoman. This is Christina and Chairman Yeager. This is Christina Wildeveld. The difference between a conditional and an unconditional pardon is when it's conditional, you do not have your gun rights back. So, and you also have to complete some terms that the board may require. However, usually the unconditional pardon, the conditional pardon is only that you don't have your gun rights. The unconditional pardon is that you have all rights back to you as a citizen. Does that answer your question?
Yes, thank you very much for that.
So convenient to have like these experts just on this Zoom call. So thank you, Ms. Wildevelt, for that answer. I appreciate you being in here and being able to answer that question for us. I'm taking a look here. Are there any other individuals or committee members with questions? Oh, I see Assemblywoman Summers Armstrong. Go ahead with your question.
Thank you very much, Vice Chair Nguyen and Chairman Yeager for this presentation and this bill. If one of your experts could kind of clarify for me the filing of an objection by the prosecutor and what that, the purpose, what that means, I would just like some further understanding.
Bailey Bordelin, for the record, I'm going to ask Sophia Romero to take that.
Sophia Romero for the record. Thank you, Assemblywoman, for the question through Vice Chair to the Assemblywoman. When somebody petitions to seal their records, there could be two different processes depending on where they're filing that petition. So if you're in the district court and you have, let's say, charges in Henderson or charges in North Las Vegas, that petition gets sent to the North Las Vegas or Henderson city attorney first, and that city attorney has the opportunity to review that and then decide whether or not to sign off on, yes, this person should have their record sealed, or no, we don't agree that this person should have their record sealed. When they choose not to sign off, the petitioner is still allowed to file with the district court, but then that means that there will be a hearing set, and then the district attorney or the city attorney will then have the opportunity to file an objection with the court and put on the record why they believe that this person should not have their record sealed. And so that is what the 10-day, well, of course, we will be discussing that time frame, but that is what the objection is for the prosecuting agency to get a chance to put on the record why they believe that the record should not be sealed for this individual.
Follow-up question, please, Madam Vice Chair.
Go ahead, Assemblywoman.
So without this clarification and the time certain set, what is happening right now if there is an objection, or does the person who is asking for the sealing get an answer? Are they just left hanging? What's going on right now that is making you all clarify this language? Thank you.
Bailey Bordelin for the record. Thank you for the question, Assemblywoman. I want to note that it is working in many places in the state. We in many counties and in many courts, we are always receiving one or the other. And so there are courts where this is not a problem. There are other courts where it is a practice. It's a choice that the statute sort of allows, I would say sort of doesn't address, where what do you do if the prosecuting attorney does not choose to respond? What is the indication there? And so individual judges have had to handle what they believe the next step is based on the statutes before you. But as you can see, it's not completely clear from the statutes what the path forward is if you do not receive a response one way or the other. So it has caused delay in some courts, and it's caused some confusion. And I would also say it's caused inconsistent results depending on which court you file in because of that lack of clarity. So we believe that by passing this bill, we would have a consistent response across the state so that everyone receives the same judicial process regardless of where they file.
Thank you, Madam Chair. Thank you, Ms. Bordelin.
Thank you. Do we have any other questions regarding this bill? Seeing none, I will give our broadcast services just a little bit of time to set people up in testimony and support opposition and neutral of Assembly Bill 119. I do believe that we have, is Ms. Wildevelt here to testify and support?
I am.
Yeager? Yes. So I see she appears to be the only person in on the Zoom. So if we could start with her, I would remind our members to the public to clearly state your name and spell it for the record. I will limit our testimony to 2 minutes on here. We will be timing each speaker to ensure everyone's given a fair opportunity to speak. And with that, we will begin with support testimony with Ms. Wildeveld on the Zoom.
Thank you, Madam Vice Chair and Chairman Yeager. Good morning. My name is Christina Wildeveld. That's spelled KristinAWildeveld. I am here both as a private attorney and on behalf of NACJ. I'd like to thank Chairman Yeager and this committee for hearing such an important piece of legislation this morning, and I appreciate the opportunity to work on this bill during the session to ensure that many of those people who want to seal their records have the ability to do so, and that the process is streamlined as much as possible. Specifically, at the direction of Justice Hardesty, we looked at the sealing process for those who have been pardoned. However, this bill works to help all individuals, even lawyers, I might add, who have difficulty navigating the sealing system currently set up. As Chairman Yeager had indicated, it is a difficult process. It's also a process that a lot of attorneys actually get bar complaints about and find themselves in trouble about because it's not as simple as one might think it is to be. This bill would help to streamline the sealing of criminal records for certain individuals, including those who have been pardoned and those whose cases have been dismissed or denied. This issue recently came to the attention of the Pardons Board when those people who are wrongfully convicted still had to seal their records of their arrest for that offense, including DeMarlo Berry, Fred Steese, Frank LaPena. However, it also addresses those who have been pardoned but continue to have to explain their criminal history or to hire an attorney to navigate the sealing process following their grant of a pardon. In addition, those who have been arrested but their cases have been denied or dismissed are also left in the position to have to continue to explain their history, whether that arrest was valid or not in the first place. The mere fact of an arrest actually shows up on your criminal record. All of these classes of individuals, as well as the legal system, including the DA's office and each individual court, benefits by this bill because the court is able to seal a criminal record without review from a prosecutor as long as the records being sealed have already been pardoned or a case denied or dismissed, hence requiring less navigation of the legal system, which makes the record sealing process statutorily defined and not left to each individual involved's discretion. There was a question earlier about the objections and when a prosecutor might object. I'll give you a specific example. If a case was negotiated with the forward thought of actually sealing a record at some point, most sex offenses can't be sealed. So if a case was negotiated so that you could eventually seal your record, and then when that statutory time ends and you go before the court to seal your record, we've actually had judges, sua sponte, call for a hearing on the case and say that they object to the sealing of the record based on the underlying original offense. This actually takes the discretion away from the judges when those cases should be sealed. It was contemplated that the record would be sealed, both by all parties involved, both the defendant, the defense attorney, and the prosecutor. But each individual judge feels that they have to make a record as to why they object to it, and then they deny the sealing process when all parties had agreed previously. So it takes a discretion out so that it's statutorily allowed rather than discretionarily allowed, so that the judges don't have as much a problem sealing the record because it's pursuant to statute. There's no rational basis for the way the current system operates when it comes to these classes of cases. It's a miscarriage of justice that the classes of cases are the denied, dismissed, pardoned, or any of the cases that might raise an objection. It's a miscarriage of justice to allow the criminal records of these individuals or whose cases are dismissed to have the offenses remain on their records. By requiring the courts to grant the sealing of the case without a hearing, if all statutory requirements are met, will allow for a more just and streamlined criminal justice system. Once pardoned, a person should not be forced to re-enter the legal system so that they may have their criminal records sealed or hire an attorney to get that job finished. This provides each of the classes with the opportunity that they need to engage with their community without the fear of their criminal past being used against them in the future, and without having to fight the system again to argue the case should be sealed or wait for the often lengthy time to be served. This is an important bill and a step in the right directions towards positive criminal justice reform. And I strongly urge your support of AB 219, and I thank you for your time.
Thank you for that testimony. It appeared that you were perhaps reading from something, so I would encourage you, if you feel comfortable, to also submit that in writing so it can be a part of today's testimony and support. And with that, we will go. It doesn't look like there's anyone else on the Zoom that has been registered. So broadcast services, if we can go to our phone lines in testimony in support of Assembly Bill, oh, what number is it? 219.
Yes, thank you. We will begin with callers wishing to testify in support of Assembly Bill 219. Callers, please press *9 now to take your place in the queue. And we will begin with caller with the last 3 digits of 611. Please slowly state and spell your name for the record. You have 2 minutes to speak and may begin.
Good morning, Madam Vice Chair and members of the committee. My name is John Piro, Johnpiro, from the Clark County Public Defender's Office. Stealing records has been a pet project of mine since 2017, and I'm grateful for all the progress that the legislature has made over the last 2 sessions in this arena. This is another step in progress, and I want to explain why it's necessary. I represented Mr. Mason, Reginald Mason, at his sealing records hearings that the Clark County District Attorney's Office opposed. They opposed Mr. Mason's record sealing, even though he was pardoned in 1998, and he had spent 13 years in prison for a crime he didn't commit when he was 14 years old. You may remember this name from a recent article on February 12, 2021, where he was awarded money from the state because of his wrongful conviction. Nevertheless, even though he was pardoned and the state opposed his pardon, they then opposed his record sealing in 2016 and made it very difficult for Mr. Mason to move on with his life. Luckily, the judge did not agree with the Clark County District Attorney's Office and allowed him to seal his record and move on from a terrible chapter in his life, from a 14-year-old young man spending years in prison for a crime he didn't commit. Getting somebody a fresh start in life is a big deal, and this bill moves that ball forward. And so we humbly ask that this committee pass this piece of legislation. And I thank Chairman Yeager for bringing this bill forward, and Ms. Borderland and members of the legal aid community for continuing to move the ball forward and helping people get their lives back. Thank you.
Thank you for your testimony in support of Assembly Bill 219. Broadcast services, if we could go to our next caller in support.
Thank you. Next caller with the last 3 digits of 725. Please slowly state and spell your name for the record. You have 2 minutes and may begin.
Hello, and thank you, Vice Chair Wynn and committee members. This is Nick Shepak, Nickshepak, Policy and Program Associate with the ACLU of Nevada. We want to thank Chair Yeager and Ms. Bordelin for presenting this very important bill. As we know, criminal records can stick with a person for life. Felony conviction can create permanent barriers that stand in the way of people's ability to move on with their lives. These records are a kind of scarlet letter that people with convictions carry for life. Pardons are designed to help those who are deserving of relief. This body worked hard in 2019 to create a path for sealing past marijuana convictions. We were not alone. In the same year, 27 states and D.C. enacted new laws creating, expanding, or streamlining record relief. Because of the difficulties in navigating these systems, from eligibility criteria that are frequently complex and unclear, to court proceedings that can be intimidating, burdensome, and expensive, many potential beneficiaries of these record sealing laws find it hard to navigate. These and other barriers to access have been shown to discourage the law's intended beneficiaries. This bill is a great step towards streamlining the record sealing process and ensuring that those who receive pardons not only have access to the sealing process, but can understand it. The appellate process added by the amendment is also a welcome addition to this bill. We urge you to support this bill for the reasons I stated and the reasons stated by our colleagues before us, and to continue to work on reform to the record sealing process to make it more efficient and accessible. Thank you very much.
Thank you. If we can go to our next caller in support.
Next caller with the last three digits of 663. Please slowly state and spell your name for the record. You have 2 minutes and may begin.
Good morning, Madam Vice Chair, members of the committee. My name is John McCormick, John, last name Mccormick. I'm the Assistant Court Administrator with the Nevada Supreme Court Administrative Office of the Courts. And Chief Justice Hardy asked me to call in today to put the Supreme Court's support of this measure on record, and also to indicate that this measure will be helpful in executing the sealing of records for those people who the Pardons Board granted a pardon for minor marijuana convictions. Thank you.
Thank you, Mr. McCormick. We can go to our next caller in support.
Thank you. Next caller with the last three digits of 037. Please slowly state and spell your name for the record. You have 2 minutes to speak and may begin.
Tanya Brown, TONJABROWN, Advocates for the Inmates and the Innocent. Thank you, Chairman Yeager and the presenter, for bringing this bill forward. This is a bill that has been long overdue. It has affected so many people's lives who have been exonerated and want to clear their names, and for those who just want to move forward and to move forward. Anyways, I would like to echo the comments made by the previous callers. Thank you, and have a good day. Bye-bye.
Thank you, Ms. Brown. We can go to our next caller in support. Broadcast services.
Next caller with the last three digits of 318. Caller with the last three digits of 318, please slowly state and spell your name for the record. You have 2 minutes and may begin.
Good morning, Vice Chair and members of the Assembly Judiciary. This is Kendra Birchie, KENDRA, BERTSCHY with the Washoe County Public Defender's Office. I want to thank Chairman Yeager for championing this crucial issue over this session, as well as in the past, with legal aid to work towards clarifying this incredibly arduous and confusing process. This bill provides our citizens with an easier way in order to receive the benefit of sealing their records that they have earned. It is incredibly impactful to hear from those that are directly impacted by this issue with exactly how important the sealing process is. For those in the committee who have some concerns, I would urge you to read or at least watch the committee hearing on March 28th, where DeMarlo Berry testified about the terrifying situation that he was in any time he was pulled over by law enforcement, because as soon as they went and checked to see his record, just the concern and confusion that it would create, despite having his paperwork and certificate of innocence. So this is an incredibly important tool to provide a second chance to allow people to rebuild their lives. Studies have shown that recidivism rates have decreased when a person has had the ability to seal their record. We urge your passage on this crucial bill. Thank you so much.
Thank you, Ms. Birchie. We can go to our next caller in support.
Yes, caller with the last three digits of 130. Please slowly state and spell your name for the record. You have 2 minutes and may begin.
Good morning, Chair and members of the committee. For the record, my name is Christine Saunders. That's CHRISTINE. Saunders, and I'm a policy director with Progressive Leadership Alliance of Nevada in support of AB 219. I want to echo the sentiments of those who spoke before me. Having a criminal record can impact employment, housing, access to student financial aid, and even being able to volunteer in your children's classroom. AB 219 helps clarify the process for record sealing, and we urge your support.
Thank you, Ms. Saunders. If we can go to our next caller in support.
For callers wishing to testify in support, please press star 9 now to take your place in the queue. And it appears there are no further callers for support at this time.
Thank you. And I'll just note for the record, we started our support testimony at 10:10 this morning, and it is 10:26. So I will be allocating the equivalent amount of time for opposition testimony and neutral testimony. So if we could go to our phone line to begin opposition testimony.
Thank you. For callers wishing to provide opposition of Assembly Bill 219, please press star 9 now to take your place in the queue. We will begin with caller with the last 3 digits of 389. Caller, please slowly state and spell your name for the record. You have 2 minutes and may begin.
Good morning, Madam Vice Chair and members of the committee. My name is Jennifer Noble, Jennifer Noble, and I am testifying on behalf of the Nevada District Attorneys Association. Pursuant to the committee rules, I'm testifying in opposition here today because we have a few suggested changes to this bill, but I would like to thank Chair Yeager and Ms. Bordelin for hearing our concerns, and we look forward to working with them so that we can get to a position of support regarding Assembly Bill 219. We have a few concerns about some of the language in Section 4, Sub 6 of the bill. Our first concern was that the 10-day time period, as was referenced during the testimony in Section 4, Sub 6, might be a little bit too short given the number of sealing petitions we've seen in recent years, because our legislature has opened up that option for a lot more people in previous sessions. For example, in Washoe County, we have a local rule that gives us 21 days to respond. It's my understanding that in Clark County, there's a 14-day rule. So a uniform rule would be good, and we'd like to see it at a bit more than 10 days, given the increased numbers that we've been seeing in recent years. We'd like to give prosecutors a little bit more time to object where they think it's appropriate. Second, we are concerned about Section 4, Sub 6 requirement that sealing be automatic if no prosecuting attorney attends a sealing hearing, as it removes the important element of judicial discretion, and it overlooks the statutory requirement that any person having relevant evidence may testify regarding the petition. Our Supreme Court has explained that sealing orders are intended to permit individuals previously involved with the criminal justice system to pursue law-abiding citizenship unencumbered by the records of any past transgressions. And it's an important step in allowing these deserving individuals to contribute to society unencumbered by that. But while eligibility for sealing is prescribed by statute, we elect and trust our judges to exercise their discretion in determining whether or not sealing is just in a particular case. Even if the prosecutor doesn't attend the hearing, NRS 179.245 allows, quote, any person having relevant evidence, as I stated, to attend and present evidence at the hearing on the petition. Those people could include law enforcement, victims, and members of the community, and they can all help inform the judge's ultimate exercise of their judicial discretion. Finally, I apologize to Chair Yeager and Ms. Bordelin because we just caught this concern this morning, so I haven't discussed it with them yet. We are a little concerned with Section 4, Sub 7B's language regarding sealing records where prosecution was declined or charges were dismissed. In certain cases, we're not able to initially file charges based on the information that's given to us by law enforcement, so we may initially decline to prosecute and then prosecute perhaps later. And in others, we may have an issue that causes us to dismiss without prejudice. And this doesn't mean we're not going to pursue charges in the future. and it can depend on a number of factors, including our ability to locate witnesses or evidence, etc. But we still have the remaining time allowed by the applicable statute of limitations to pursue those charges. And it also appears as drafted, and I don't think this is the intent, that this section may apply to persons investigated or arrested for charges not ordinarily eligible for sealing or with no statute of limitations, like sexual assault or murder, certain crimes against children. So we just ask that we apply a period of time commensurate with the statute of limitations applicable to the particular offense or offenses that are being considered to that section. Hopefully that makes sense. As always, we really appreciate your consideration, our concerns, and we are looking forward to working with Chair Yeager, Ms. Bordelin, and all the stakeholders on this important bill. Thank you.
Thank you, Ms. Noble. Broadcast Services, can we go to our next caller in opposition?
Yes, thank you. For callers wishing to testify in opposition of Assembly Bill 219, please press star 9 now to take your place in the queue. And Vice Chair, there are no further callers for opposition at this time.
Thank you, Broadcast Services. I would just note that we are concluding opposition testimony at 10:32. If we can go to the lines for testimony in neutral of Assembly Bill 219.
Thank you. For callers wishing to testify in neutral of Assembly Bill 219, please press star 9 now to take your place in the queue. For callers wishing to testify in neutral of Assembly Bill 219, please press star 9 now to take your place in the queue. And Vice Chair, the public line is open and working. However, there are no callers at this time.
At this time, I will welcome Vice Chair Yeager back to the virtual table to see if he has any closing remarks.
Thank you so much, Madam Vice Chair, Steve Yeager, for the record. Record sealing is an issue that we've been working on for a lot of years. It's overly complicated in the state of Nevada. I think this helps move the process forward. I want to thank Ms. Bordelin, who has done tremendous work in this issue, and Ms. Noble as well. The DA's office has been very willing partners to talk about these issues, and I understand we had a very tight turnaround from when the bill was introduced to when we're hearing it. So I appreciate her expressing those concerns and a willingness to work together. And I do believe we're going to be able to find some common ground here to hopefully make this process just a little bit simpler for those who really do deserve to have their records sealed. And so, Madam Vice Chair, with that, I would just hand it over to Ms. Bordelin if she had any concluding remarks, because she's done most of the hard work on this bill.
Go ahead, Ms. Bordelin.
Thank you. I appreciate that, Bailey Bordelin, for the record. I would just echo that we appreciate Chairman Yeager always making progress in the area and the committee's willingness to look into this. And we do hope to come back with something that everyone agrees is a workable step forward. So thank you and happy Friday.
It is a happy Friday. And with that, I will conclude and close the hearing on Assembly Bill 219. I will welcome back our chair to conclude this meeting.
Thank you, Madam Vice Chair, for running the meeting. I think we need a gavel emoji on Zoom so we can actually pass the gavel back and forth. Maybe that's an upgrade. Oh, you have one in front of you. I don't have an actual gavel in here. So anyway, committee, thank you for your attention this morning. And before we conclude, I'm going to go to our last item on the agenda, which is public comment. By way of reminder, we have 30 minutes for public comment at the end of each meeting. Public commenters will have 2 minutes to provide public comment. Public comment is a time to provide testimony about matters of a general nature that are in the jurisdiction of the Assembly Judiciary Committee. BPS, could we go to the public comment line and see if there's anybody there who'd like to give public comment this morning?
Thank you, Chair. For callers wishing to provide public comment, please press star 9 now to take your place in the queue. We will begin with caller with the last 3 digits of 556. Please slowly state and spell your name for the record. You have 2 minutes to speak and may begin.
Anne Marie Grant, ANNEMARIE GRANT, sister of Thomas Purdy, who was killed by Reno police hogtied for 40 plus minutes and asphyxiated to death by Washoe County Sheriff's Office while still hogtied and put in the prone position while several deputies got on his back and neck area. I would like to thank all the committee members for their hard work. I see a lot of bills coming down the pipeline that look good. AB 243, I just wanted to mention that I did send an email to the sponsor of the bill. I do think it impacted, person directly impacted by police violence should be on that committee that's being suggested. Today I want to talk about Roy Anthony Scott, who was killed March 3rd, 2019. In a time when George Floyd's death took national headlines, I think it's time to acknowledge Nevada's own George Floyd. Roy Anthony Scott was killed on March 13th, 2019. He had called police saying that there were armed men or an armed man outside his home. When police came, he initially wouldn't open the door, told them to kick it in. When they ended up going to leave, he came out then and they attempted to handcuff him. And that's when he became resistant, asking, why are you doing this to me? And that is when he too was then placed in the prone face down position. And Las Vegas police, I believe it was, then put their knee in his back and neck 63 times. He pleaded please 63 times in a matter of 8 minutes. Please support bills that promote transparency and accountability. Please do not support bills that protect police any further than they're already protected by the police officers' Bill of Rights. Thank you.
Thank you for your public comment, Ms. Grant. BPS, are there other callers for public comment?
Yes, thank you. We will go with caller with the last 3 digits of 216. Caller with the last 3 digits of 216, please slowly state and spell your name for the record. You have 2 minutes to speak and may begin.
Hi, my name is Anthony Thomas Jr., ANTHONYTHOMAS JR, Anthony Thomas Jr. I'm an ambassador with Make It Work Nevada, a member of the Nevada Housing Justice Alliance. Nevada has one of the fastest eviction processes in the country, and this process is disproportionately impacting Black and Brown families. We need a hearing for AB 161 in order to protect Nevadan families and to keep them in their homes and ensure they have right to due process. That's all I had to add. I want to say thank you guys, and I appreciate you taking your time out to have a good hearing today.
Thank you for your public comment, Mr. Thomas. BPS, are there other callers on the line for public comment?
For callers wishing to provide public comment, please press *9 now to take your place in the queue. Chair, the public line is open and working. However, there are no further callers at this time.
Thank you, BPS, for helping us with all the testimony this morning. Definitely appreciate it. I'm going to close public comment. And before we talk about next week, anything else from our committee members this morning? I don't see anything. I know it's been a really long week and it was a long meeting, so thank you all. I wish I could promise you that things would slow down, but I think to the contrary, things are going to get busier from here on out as we continue to get more bills. In terms of the schedule next week, we have agendas out for Monday and Tuesday. Monday, we're going to start at 10 a.m. So hopefully that'll give folks a couple extra hours. A reminder that it's daylight savings time this weekend, so we're going to lose an hour on Saturday night, Sunday morning. So we'll have a 10 a.m. start Monday. We'll be hearing one bill. Tuesday agenda, we're starting at 8. Right now there is one bill on the agenda. We may add some additional bills. We don't have agendas out for the rest of the week, but just in terms of planning, I do anticipate we will probably have Assembly Judiciary Committee every day next week, and likely 8 o'clock starts after Monday as we'll try to get through bills. So make sure you get some rest this week. This weekend, next week's going to be long as well. Thank you all again. I hope you have a wonderful weekend and you stay safe out there. And we'll see you back in this committee Monday morning at 10 a.m. This meeting is adjourned.